staffers for committees and like these positions.
Good morning. I'd like to call this meeting to order. The time is 9 a.m. on the dot. Today is Wednesday, September 18th, 2024. This is day 2 of a 2-day meeting of the Physical Therapy Board of California. Today we are meeting in the hearing room at California State University, Sacramento, 6016 J Street, Sacramento, California. This is an official business meeting of the Physical Therapy Board of California. This meeting is being recorded and minutes of the meeting will be prepared. May we please have roll call?
Tanya McMillian,
Present.
Dale Armstrong. Dale Armstrong is absent. Karen Brandon,
Present.
Katarina Ellaby. Katarina Ellaby is absent. Sam Q,
Present.
Alicia Rabene-Men.
Here.
All members are present with the exception of Katarina Ellaby and Dale Armstrong, and the board has a quorum.
Thank you. May I please ask Dr. Alicia to read the board's mission statement?
Forgive me, I thought it was on this front page. Okay, here we go, thank you. The board's mission statement is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you. And so now we will pick up with the next agenda item 15, our Consumer and Professional Associations and Intergovernmental Relations Report.
Good morning. I will start with the Federation of State Boards of Physical Therapy, FSBPT update. Mr. Kaiser has been serving on the Sexual Boundaries Task Force. The task force has created several resources for licensees, educators, and recently students, including electronic and printed materials, as well as some videos. This information is being disseminated at a national level for all physical therapy licensing jurisdictions. Once complete, the PTBC will be adding this information to its website. Also, the FSPPT has created an audit tool that licensing jurisdictions may use to assess their website for trauma-informed approach performance. For example, is the website and/or complaint form a barrier for complainants? Is it hard to get to? Are there questions that might trigger a negative reaction with the complainant? Is the information available and readily accessible and easy to digest regarding patient and provider boundaries? So that tool is available on FSBPT for all the licensing jurisdictions to use, because there's a movement right now with the FSBPT to look at a trauma-informed approach and just making sure that we are being sensitive to consumers and what they may have experienced.
Can we ask questions now or at the end?
Yeah, go ahead. That's
Okay,
all I
so for that tool, is that something that staff is looking to implement or like assess if that'd be useful for us?
have. Yes, yeah, we
Okay.
can use that. I don't have information on that right now, but that's definitely something that we are looking at to do, and we've started that process, but we can report back on updates on that.
Yeah, I'd be interested in like maybe an example.
Okay.
Yeah, thanks.
And that's all I have as far as FSBPT.
No report on life or the annual meeting?
No, I don't have anything on life for this update. For the annual meeting, Mr. Kaiser shared that he will be attending remotely. Mm-hmm.
Any board comments, board questions for 15A FSBPT report?
I was at the live meeting, and it was a very, very lively meeting, and they actually had a lot of breakout sessions, and then actually sessions that we played sort of games, but all involves with the missions and goals of the Federation. And one of the things that did catch me was the talk about artificial intelligence, that the role and the future regulations and how that interplay is going to be in terms of how the profession is going to implement that, and how regulators going to be looking at AI. And this is at a very early stage of it, and of course it's lots of suspect of how that, especially related to the treatment side. I think there's a lot of concerns from the boards all over the country, and then I think there are some level of that is being used right now, but the argument is that whether that should be assessments should be used instead of professional judgment by the PTs, and so that's going to be a sort of a point of debate. It's going to be continuing, and also I think they talked about the compact quite a bit again, and talked about the exam, and which is now that we have implemented our side of the exam, so it's something that the Federation is very keen about, and I wanted to make it more uniformed. And that's all I sort of grabbed me, those points. Yeah.
Thank you for going for us.
Oh,
Yeah.
you're welcome.
Yes. Any other board comments? Ooh. Any public comment on section item 15A? Hearing none, we will move on to 15B, Department of Consumer Affairs, DCA Executive Office.
Can everyone hear? Oh, yes, everyone can hear me. Thank you. Good morning. My name is Judy Bucciarelli, and I'm from the Department of Consumer Affairs Board and Bureau of Relations. On behalf of the department, I would like to thank the board members for their service and dedication to protecting the consumers of California. So before I get going this morning, yesterday Sarah covered the first two items on my report in regards to the budget letters, and both her and Michael were able to expand, on the impact to the Physical Therapy Board. So I'm going to go ahead and cover those. That's what my manager would like me to do, so I apologize for any redundancy. Budget Letter 2420, Vacancy Savings and Position Elimination. Work continues to address the state's budget deficit. At the end of July, the Department of Finance issued Budget Letter 2420 that outlines the assumed reduction of the state's workforce by 10,000 vacancies and $1.5 billion. The Department of Finance estimated a target reduction for each state department by reviewing the department's vacancies and then assuming half of the savings from those vacant positions. DCA worked closely with the agency and each board and bureau to provide detailed notes, requested exclusions, and justifications position by position. DCA submitted a proposed vacancy reduction plan to the Department of Finance in mid-August and is awaiting its approval. Next, Budget Letter 2424, Government Efficiencies Reductions. Additionally, on August 16, 2024, the Department of Finance issued Budget Letter 2424, which outlines the reduction of state departmental budgets by 7.95% in order to achieve state savings of $2.1 billion in 2024-25 and future fiscal years. DCA is identifying fixed cost exemptions that cannot be reduced, such as Office of the Attorney General and Office of Administrative hearings, so they can be excluded from consideration. The final budget reduction plan will be submitted to agency and the Department of Finance for approval later this month. DCA's Budget Office continues to work closely with each board and bureau on these reduction requests, while always balancing our mission of consumer protection. These are challenging budget exercises, and the department would like to acknowledge board and bureau leaders for their thoughtful and diligent efforts, often under very quick deadlines. DCA will continue to share updates from the Department of Finance as they are received. As a reminder, DCA boards and bureaus must continue to scrutinize expenditures and maximize cost savings, only authorizing expenditures that are mission critical and essential to operations and public services. My last item is a innovation recognition. DCA is very proud to share that on August 20th, 2024, Jason Piccioni, DCA's Deputy Director for the Office of Information Services, was honored for developing DCA's Federal Professional License Portability and State Registration Portal. Jason received the Best of California Award in the Innovation Serving the Public category at the 2024 California Government Innovation Summit. Launched last fall, DCA boards and bureaus have accepted over 176 individuals to practice in California through this online portal. DCA did not receive any additional funding or staffing for its implementation and has worked hard to ensure it is efficiently serving military services members and their spouses relocating to California. The online portal Jason designed and implemented has been used by the U.S. Department of Defense as a model for other states. This concludes my DCA update for today. I'll turn it back to President McMillian, and I'm happy to answer any questions from the board.
Any comments, questions from board members?
Thank you for the update and for being here. My question is more of a concern, and that is with the quorum of this board. So we're a board of 7, and there are 4 of us here. And I was pretty surprised when I got here that there were 4, because, I mean, if just one of us, for some reason, just can't make it, we would have had to cancel the ALJ. You know, the petition would have had to be rescheduled. We couldn't do board business, basically.
Right.
And so I think I probably bring this up at every meeting, these quorum issues. And so I'm just hopeful that maybe together, Sarah and Jason and DCA can work on maybe getting some appointments soon, because 2 of us will be terming off in March.
Right.
Yeah, and then we'll be at 4 and really be in trouble for quorum if somebody can't make it. So that's just my concern.
Okay, what I can do is I'll take that information back to my manager and make her aware that the issue's being raised again, and hopefully she'll reach out to Sarah and Jason.
Thank you. I just want to add to that Mr. Kaiser is in communication with board and bureau relations and keeping an eye on and trying to get the appointments and get the vacancy filled, and so definitely on his radar as well. And so hopefully soon. But thank you.
Any further comments from board members? Any public comment? other than this tilting table? Hearing none, thank you so much for your
Okay,
report.
thank you for your time today.
Moving on to item 15C, California Physical Therapy Association, CPTA.
Madam President, it looks like we do not have a representative here yet, so if you, maybe we can take that later in the agenda.
Okay, so we will
Thank you.
move that till later. Okay, before we move on to item 15, before we move on to item 16, we're going to take a 5-minute break just to make sure that all the equipment is set up, that we're good to go, and then we will move forward. 5 minutes. 5 minutes. So Okay, welcome back. And so now we will commence with item number 16, ethical decision-making and Bagley King presentation by our legal counsel, Michael Kenotes.
Thank you, Madam President. For those who don't know me, I'm Michael Kenotes. I'm the board's legal counsel. Was discussing with some board members this morning that it's been over 5 years, and really appreciate all of your work and working with you. Today we're going to do a little presentation on the Bagley-Keene Open Meetings Act and ethical decision-making. Forgive me, I need to stand. I'm an old trial lawyer, and it's just sitting and presenting just doesn't work for me. What is the purpose of the Bagley-Keene Open Meetings Act? To promote openness or transparency in state decision-making, to require a state body to do business in public and not in private, except where expressly permitted, to provide the public with adequate notice of the items to be discussed at the meeting, and to provide the public the opportunity to comment before the state body takes any action. You know, I have an old friend who lives in Pennsylvania and is the director of a vocational technical school. And he was sharing with me a while back his experience going to a local government public meeting. He showed up and there were no signs. The front door of the facility was locked. He literally couldn't get into the meeting. And that's sort of where his little journey that night started. And my thought was, don't you have an Open Meetings Act? Like what? And the response was that there's nothing like that in Pennsylvania. So the state of California is very progressive in terms of its sunshine laws. And just very briefly, the Open Meetings Act is part of that scheme of statutes that allow the citizens of California to really get a lot of information about what happens in state government. There's also, in addition to the Open Meetings Act, there is the California Public Records Act, which is based on the Federal Freedom of Information Act, but is actually much more expansive and you get much more, and it has very specific time requirements in it. There is also, at the local government level, the Brown Act, which basically substitutes for Bagley-Keene and the Public Records Act for local government or any other districts, and really any governmental entity that is not part of the state government is covered by the Brown Act. And then there are also really good strengthening laws, the California Information Practices Act, which requires if the state government has information on you, they're required to give it to you and tell you what that is. And it also requires the confidentiality of that type of information when others are making Public Records Act requests. So that's why we redact a lot of information there. And also the Damali-Baltour Language Services Act that requires translations of government materials into different languages. So California really does try to get the public engaged, wants the state's business, including state departments, but also boards, commissions, other groups, other state bodies that make decisions to do so in this very open and public manner. So at times we really, at least from the legal division, at least from my perspective, we try to keep that in mind and err on the side of disclosure of records or openness for a meeting, or being careful that our agenda reflects what's actually going to be discussed at the meeting, rather than, forgive me, but rather than buzzwords and sort of committee report. We don't really know what sometimes that discussion is going to be. Okay, so the Bagley-Keene top 10 list. All meetings must be held in a place that is accessible to the public. So this is a great example. We're in a public state university. The doors here are open. That's a good thing. And at times this issue comes up more with teleconferences, because also when you have a traditional teleconference, all of those meetings also have to be open to the public. And at times we have members who want to use their personal home, which is not a good meeting place. It's not a public place, and you'd be required to let anyone in your house who wants to come to the meeting, who happens to live in your town. Also, some public places are too public, right? So a Starbucks is not a good place to have a public meeting. Interesting though, a public park can be a great place for a meeting if you can manage that. And sometimes I've had teleconference locations be, Pavilion 5 at, Washington Park, and that suffices. And at any point, if anyone has a question, feel free to stop me. Don't mind that at all. Please feel free to engage and ask questions and share examples if you'd like. Meetings must be noticed 10 calendar days in advance, including posting on the internet. So when we put out an agenda for a meeting, there are a lot of things that happen behind the scenes. At DCA, there's the internet team that posts all of the requirements, and there's a process by which the legal division, I review all agendas for my clients, and it actually gets a second level of supervisory review to really just make sure that we are crossing all of our I's. I always say that wrong. We are dotting all of our I's and crossing all of our T's in terms of the information. And of course, that has to happen 10 days in advance. It is also true that we cannot amend an agenda to add items after the 10 days. Sometimes I've had clients wanting to try to get around that and do that, but truly it's as if we are posting a new agenda for the meeting when that happens, unless it's a a technical change or those type of edits can be allowed at times. Madam President.
So, in the event that somebody does not have access to the internet, those 10 calendar days, do they take into account mailing and the time for the postal service? Is that, or when do the 10 calendar days count when not using speedy transmission?
There is not. There's not a allowance for that in the 10 days. It's 10 calendar days. So for your meeting, the meeting, okay, I'm not going to try to do the math here, but it's 10 days, and then the meeting is the 11th day that you have to do the notice for. And there's not, the reason for the 10 days, I think, is to give time for those types of things. And a lot of boards, your board generally posts your agenda well in advance of that. You utilize your email listserv to provide notice to folks, and that goes to constituent groups and individuals, and I get them because I've signed up for them. The days of doing paper meeting announcements, I think, are sort of bygone, and it used to be that you had to publish in a newspaper. And there used to be okay, I'm dating myself. There was sort of a Capital news, I'm not going to remember the name of it now, but there was a daily sort of Capital, or maybe weekly Capital newsletter that everybody published their notices in. So it would be, the first half of it would be content and ads and whatever, and the second half would be all these notices for public meetings and everything else. But folks knew that they could access that and find out all the meetings that were going on around the state. Judy.
Is that the same for emergency meetings?
No. So there are, and I didn't go into that, I didn't want to get too in-depth on this, but there are special meetings which can happen with 2 days' notice, and then there are emergency meetings that can happen on an immediate basis, and there are very specific We usually don't have the criteria for that, but like, for example, one of the potential criteria for which you can have an emergency meeting is if there's litigation and there's a court deadline that's within the 10-day period. If there's legislation and suddenly it changes and the board wants to weigh in on that and there's a legislative hearing in 5 days. So those are a couple good examples of what we would use an emergency meeting for, or a special meeting. So let's see here. That really dovetails into number 3. An agenda is required for every meeting, which must include a description of the items to be discussed. And no item may be added to the agenda unless it meets the criteria for an emergency. So, and back to the point about amending an agenda, you can amend an agenda, and at times that will happen. You have a regularly scheduled meeting, and then you realize that you have something you need to discuss right away. And you can do that at the meeting by adding the item if you have the grounds to consider it as if you have grounds for an emergency meeting, that can be done as part of the regular board meeting as well. So a meeting is a gathering of a majority of the board or a majority of a committee of 3 or more persons where board business will be discussed. It includes, or can include, telephone and email communications, and we'll get to that part in a moment. So with Bagley-Keene, there is what we sort of refer to as the rule of 3. You can have a 2-person committee, and the committee can meet without there being public notice and an agenda and all the items that are covered by Bagley-Keene. If there's 3 members, then at that point, the requirements of the act take over, and you must comply with those requirements. At times, committees will still, that want public input, of course, will still post and create agendas and invite the public into those meetings. But there's other times where it's very appropriate for a committee of 2 members to meet to really just sort of get their own understanding of an issue and then move to and then make a recommendation which will be heard at the full board meeting. And that is sort of the substitute for the public's ability to be at the committee of 2 meeting, because they have the opportunity to comment at the actual meeting. Sometimes it's those smaller committees, or you roll up your sleeves and you sit down and you do the work, and then the opportunity for public comment comes in. But that's a good rule of thumb as well. At times when we have committees, the committees will take action to make a recommendation. And that's great, because the committee agrees what they want to do. But that action really doesn't do anything, right? Because the committee doesn't have the authority to take action, the board does. And then the board will take up the matter and allow the public comment to occur, going to be discussed at an open meeting in a place accessible to the public, been agendized properly, and we comply with the Open Meetings Act there. So the Open Meetings Act applies to all boards, committees, subcommittees, and task forces that consist of 3. Got a little ahead of myself there. And that includes all persons, whether they are board members or not. Little anecdote, if there is a purpose for this, you can have a committee meeting that includes board members and other members. I am also currently the attorney for the Board of Accountancy, and they have several committees that are mostly composed of non-board members. There will always be a board member or 2 on the committee, but they invite people into their committee process to get views of different folks around the profession. So those are always options, especially with a larger board that has a lot of business. At times your board has the ability to have those types of discussions during your regular board meeting. But again, the rule of three applies. And, you know, sometimes we have, like, for instance, my suspicion is that some of the changes to the Open Meetings Act really that sort of limit our now, and we'll get to this, that limit our ability to do fully online meetings. What the legislature really had in mind there were other boards and committees and task forces, like the Coastal Commission, like the State Personnel Board, that really exercise a lot of authority in the way that state government, the Public Employee Relations Board, the Public Utilities Commission. So unfortunately, when Bagley-Keene is amended, it applies to everyone, regardless of the need for, at times, certain items. But we'll get to that. Public comment must be allowed on agenda items before or during the discussion of items and before a vote. That is pretty self-explanatory. Yes?
Sorry. Before or during the discussion of the items before a vote. So that can be after the motion and the second.
So if it's an agenda item that does not contemplate action, you take up the item, you do the item, you perhaps recognize the fact that there's not going to be any action, like a report. And then usually the modus operandi is to ask for public comment at the end. But at times boards want to hear from folks, and then they want to be able to have an additional discussion based on the comments. So that can happen at any time during the, and a good example, I think, is if I recall our board meeting last December, there was a lot of, during the, hopefully I have the timing right, during the presentation on the Sunset Report, there were a lot of times we stopped. We could have waited until the very end, but we stopped because there were a lot of different topics within that, and to allow the public to respond sort of jot for the different pieces and proposals that were a part of that. What I do is if that happens and then there's further discussion, at times I will, unless it is sort of repetitious and, oh, thank you for your comments, and then they repeat what they already said, at times I will, if there's any more substantive discussion, I will instruct the board president or chair to open it again for public comment, because the public still has the opportunity to comment, so the public has the opportunity to discuss those matters that came up in the discussion subsequent to the first public comment period. But the really important point here is before a vote, if we're taking action on an item, asking for public comment there is really critical, because if we don't and we make an important policy decision, then any party can file suit under the Open Meetings Act and invalidate the decision because we didn't take public comment. So that is sort of always the risk, and that is part of why we also, your lawyers always recommend to err on the side of disclosure, on the side of allowing more public comment, and rather than trying to constrain that. Boards that do that end up in bad situations at times, politically and in the media, especially if they're controversial issues. It's always good to allow public comment. Never wrong to open for public comment. Closed session. Well, that's a strange place to start. So one member of staff must be present during closed session as the note taker to document the topics discussed and the decisions made during the session. In the context of professional licensing boards, there are a lot of other reasons why closed sessions can happen in different boards and bodies and commissions throughout state government. Really, these are the only ones that apply here. So to discuss and vote on disciplinary matters under the Administrative Procedure Act. And that can include everything from stipulations, proposed decisions, interim suspension orders, probation revocations, and petitions. So we don't necessarily need to notice petitions separately, but we do need to, even though it's going to be in a closed session, on the main agenda for the meeting, we need to list those items that we're discussing in closed session. Prepare, approve, or grade examinations. So in the bygone days, a lot of boards really did sit down in closed session and go through, with the red pen and grade examinations. We have since, state law has, this is sort of still on the books, but state law around examinations has evolved such that is a much bigger process than, obviously we're not going to do that. But in the case of your board, you have FSVPT that creates those exams for you, and they're validated, and then you have the national exam, of course. I don't have to tell you these things. But at times, there are still items that are appropriate to take up during closed session. Sometimes we have I think we had the Office of Professional OPES. Okay, there we go. Come into our closed session because there's information in their presentation that could jeopardize or give candidates sort of clues on what's on the examination and are just not appropriate to discuss in a public session. So that would be we can prepare an examination. That sort of falls under preparing an examination. Even if we're having discussions with our consultants that are going to review the examination, we think that fits there. At other times, those discussions will need to happen in open session. Any questions there? Okay. To discuss pending litigation. There is one special rule for pending litigation. Rather than just say, like in A, we're going to vote on disciplinary matters under the APA. For litigation, we do have to list specifically the name of the case and some general information, the court, the case number, generally we put in there, in order to be able to discuss that. So the public knows we're discussing it, but they're not going to be privy to the conversation. That happens in closed session. There are other times, and this doesn't happen very much for us, we don't generally litigate too much in terms of filing regular legal actions in Superior Court or defending those. I mean, sometimes we do. But if we had cause to do so, if we were planning to file a lawsuit, or if we're coming together to discuss what we believe is going to be a lawsuit against us, we can do that in closed session before there is actually a case filed. Again, it doesn't really come up very much here. It has come up with some other boards, and that's a situation we don't want to be in, because it means we're in litigation, as opposed to the writs that go to Superior Court that are really part and parcel of our administrative disciplinary decisions.
Is that one of the requirements to list the case or the person bringing us to litigation?
Yes. So if that were the case, we would have to, there would be no case name, but we would have to very carefully state what the issue is. So we would have to say something to the effect of, to discuss potential litigation on this subject. And I think that gets us there. Okay, to discuss the appointment, employment, or dismissal of the executive officer. You folks have a wonderful executive officer and assistant executive officer and staff. And you've had that executive officer for as long as I've been here. So we haven't gone through this in a while. But if there is a change in the executive officer, the interviews, the preparing the job listing, the job description, reviewing applications, and then ultimately interviewing, discussing, making a hiring decision. All of that has to happen in a closed session.
Employment doesn't cover evaluation?
Well, this is incomplete. Yeah. Yeah, it does. The evaluation is also something that we can do in closed session. And, go ahead.
Does that include a staff member?
Usually not, no.
Did you
So let me, go ahead.
Did you list this like verbatim, or is this just truncated from?
This is all truncated. Yeah.
So do you think that the original language states EEO evaluation? Or
So
do
I
you
think
this falls under employment?
this is, yes. Yeah, so this is I could have been more descriptive about that here. Sorry, I'm critiquing my presentation here. But yes, the appointment or employment, this is what we proceed under. But that happens in a very systematic way in the department now. At times, we can invite, and a lot of boards do, invite the Office of Human Resources, sends a representative, and sort of conducts the evaluation and discusses that with board members. You all do that in a different manner, and you do a good job at that. Some boards really need that assistance to put together the evaluation procedure. There is sort of a fine point there, and when we get together to discuss the employment or evaluation of the executive officer, or it could be other officers too, but we generally don't do that in this department. There are things that we can discuss in closed session, and then there are other things that we have to discuss in open session. And I think the good distinction is, of course it's not personal, but if it's personal to the employee or the executive officer, if we're talking about their performance, their actions, their employment, whether to give them, whether the board should or should not give them a increase in compensation. Those are the things we can discuss in closed session. If we're talking about the appropriateness of the state classification or the CEA level of an executive officer, there we're talking about the office. This doesn't have anything to do with who's currently sitting in it. We're talking about the office and what is appropriate given the work of the board, the complexity of the board, the number of licensees is something that's looked at there as well. So again, those things are, so if we're talking about whether I'll use myself, whether Connotes gets a raise, we do that in closed session because it's about me. If we're talking about the fact that perhaps we think our executive officer position should be higher level of compensation or lower level of compensation, then that is something that would have to happen in open session. Karen?
How's it agendized?
It would be, for the closed session, it would be, there'd be an item that says to evaluate or to discuss the evaluation of the executive officer. If we were going to do that in open session, I would agendize that as discussion on the classification or CEA level of the executive officer position. Something to that effect. That's not a very good.
I think, in general, this board has done a good job with that distinction, and some of the confusion has happened outside of this board, because we've had to explain ourselves over and over again, the difference between the two. But I do have an example. If in closed session, the board decides, yes, we'd like to, give a raise. And the board would like to know from the president if and when that raise has happened. Because that merit increase is specific to that executive officer, isn't that something that would happen in closed session?
Well, Well, the point of decision is whether to give the raise. That is what needs to happen in closed session. If perhaps the board president wants to follow up on those matters, it would be appropriate for the board president to do that, or vice president in their absence. That's not something that really even requires a closed session. That's sort of helping administratively behind the scenes to effectuate what the board decided in closed session.
And I think what the board is waiting, what board members are waiting for is what was the decision to our request? Like, we want to know, we decided on a merit increase. We want to know, was that addressed or not? That's what we want.
Okay.
What's the process of getting it reported back to the board?
Well, that's sort of an internal business process within state government, and those changes. I'm not the best person to discuss this, but government is organized into departments, which technically are part of the Department of Consumer Affairs, and then agencies, which are gubernatorial appointees. We're part of the Consumer Services, Housing, and why can I never get this right? Can someone help me? Consumer Services, Housing, and Business. Yes. So we're part. I was under the Health and Human Services Agency for so long. I for some reason I can't keep that title down. So senior moment. At that level, that's basically the level of the administration, the governor's administration, that oversees state government. So each agency has a number of departments or smaller commissions, boards, little things attached to it that they oversee. And they make the ultimate decisions on the higher level appointments. So a CEA technically means career executive assignment, not career ends abruptly, but that can happen at times too. And those are really considered gubernatorial appointments. And so they go through that process. I mean, it begins sort of at the department because you sort of have two overseers, right? You have the department, and then there are those areas where the board has a lot of independence, but at times it has to, Cal HR also sets standards for that, and some of those requests, or all of them, may have to go to Cal HR as well for approval. Yeah. But if, for example, the discussion on the executive officer's evaluation, potential raise, if that goes through that process and the board wants to discuss that again, and we're talking about the individual I'm pointing over here, but Jason's not here. That's a discussion about their private employment information, that can happen in closed session again, and we could agendize that. But what has to be separated again is the distinction between something that is personal and part of the employment relationship of the current executive officer, and then something that is going to be changed that will apply to any executive officer from now till the end of time, perhaps.
Yeah, I think, again, we're pretty clear on that. Really, the basic question is, did he get what we asked for 3 years ago or not? Because we're continuing to do evaluations every year, and, sometimes we just don't hear back.
Right. Well, I'd suggest that if that's ever the case, I think your first stop is the Board and Bureau Relations. That's their role to assist you with those matters.
I think our first stop is DCA exec, and then.
We're those are 6 of one, half dozen of the other. So it really is they are part of exec, but they're sort of your they're sort of your first line of discussion, and they do a good job, and they're very helpful. At least that's what I've found. I don't know about in those matters, right? But overall, Judy's team does a good job with those items.
And so I want to go back to number 7. It says that a member of staff must be present during closed session as the note taker. And, well, of course, we don't have someone present when we are evaluating the executive officer's performance.
Well, this is sort of one of those balancing of different interests issues, and this happens quite a bit in state law. So on one hand, yes, that is true. We're supposed to have a note taker. On the other hand, we have an employee that we're evaluating that has a right to the confidentiality of that, and really there's no reason to expose, especially a member of their staff, to that, and that can be very detrimental. So what generally happens is either the representative of from Human Resources is essentially the note taker, or if you have counsel with you in closed session during the evaluation, counsel can certainly be the note taker. If you don't, and that's acceptable, and I think that's what your board does, then basically it falls on the board president. Yeah. Oh, you're quite welcome. Any other questions on? I know this is a hot topic for the board, and I think that's a very natural thing to happen with a profession like physical therapy, where you have a pretty constant growth in your licensing population, which is, I don't know if it's 1-to-1, but is also representative of your increase in workload. Okay. A closed session is not permitted for election of board officers and discussion of controversial regulations or issues. At times boards make the error of thinking that this is something really important. We don't want the public to see this yet, to talk about this yet, and unfortunately those are things that we can't do, except for, to the extent that we want to use a 2-person committee to flesh out some of those issues and then bring it before the board. But again, that is a situation where the public's ability to comment and present what they would like the board to hear, that happens at the board meeting.
We keep referencing a 2-person committee. Is that a committee that is created by the president ahead of time, that's identified that these two will be working on X, Y, and Z?
Correct. And that,
At the board meeting, in the middle of, like, talking about something that's agendized. The process of talking about something that's agendized, the president might identify, I'd really like for us to evaluate this issue further. Would you mind? I'd like to take a call for committee members for this.
that is absolutely one way that a committee can be formed. And that can be very effective and expeditious at times. There are 2 types of committees. There are standing committees and there are ad hoc committees. I don't know that we have any standing committees right now. No. Some boards have regular standing committees that meet regularly. Some of them are 3 persons or more, and some of them are 2 persons, and they don't have to be noticed. But the president has broad authority to appoint a committee, create a committee on an ad hoc basis, and that certainly can be done during open session, during the discussion of a particular item. The president can also just do it and appoint the members, and if they're willing to serve, that can all happen behind the scenes as well. And with some boards, the committee assignments are very are recruited from outside the board or inside the board, and there's a lot of discussion on who's going to be on that committee. So at times it's the board president making those decisions, unless the board president wants to delegate to the board and have a discussion and appoint people. Anya?
So this might be a no-brainer, but for the controversial regulations or issues, would said regulations or issues have to be agendized? And do they have to be something that impacts the board directly?
Yes, or at least indirectly. I mean, and the point here is we can't do any of that in closed session. But the board has really broad authority to hear items and discuss potential legislation and regulations that happen that could affect the board in any ways, including the budget of the board. So that is certainly something that you can agendize and talk about freely. Usually what we're talking about there are regulation packages, and those are agendized in a particular way. At some point, there is a requirement for board action, and the Office of Administrative Law really does look at those issues. They look at the materials that the board considered during the adoption, during their approval of the regulations package. They will look at the minutes to see how it was discussed, and it's almost sort of like legislative history in terms of the way it's looked at by the office and the way it would be looked at by a court if a regulation needed an interpretation. They really would be looking back at your board materials. They'd be watching the recordings of the board meetings to see what board members said. They'd be looking at your minutes. So those can be very important discussions, and that's something that your regulatory counsel would help prepare so there's a good record for the promulgation of the regs. And actually, I missed that. In terms of open government, that is a very progressive, that being that we have an Office of Administrative Law that approves regulations, is part of the Administrative Procedures Act, which requires the notice to the public, and public requires, well, it enables public participation in that process to the extent that individuals who make comments on a regulation, the board or State Department, whoever's promulgating the regulation, has to actually review them and respond in some way. So that is a very progressive open government policy, because it used to be administrative departments just adopt a regulation and here it is, folks, and you can sue us if you don't like it. It was basically how you had to, if you wanted to change that or affect or even provide your views on that. That was basically the option that you had, at least within state government. Okay, let me just take a moment and think here if there's anything else we should cover here. Anyone have any questions on what we've gone through so far? Closed session? Okay. Each member's vote must be recorded. Secret ballots or votes, except for mail votes, on APA enforcement matters are not permitted. So mail voting is sort of interesting because it's almost like a straw poll, and if there's enough votes to adopt or not adopt the stipulation, the proposed decision, I think it's a view. The idea is that it's a procedure by which the decision-making process can be expedited. But of course, all boards have procedures by which a member can hold the item for closed session. For some boards, it's one member, smaller board, and that's you folks. You only require one member to hold an item. Larger boards at times require two. Idea being, if everyone else agrees and we have one person that wants to hold it, that, if the vote's going to be 12-1, we're not going to hold it for just the one person. I mean, some of that is mail voting. I wanted to talk about that a little more. So the mail voting process would actually violate the Administrative Procedure Act. But there's a special statute that authorizes that procedure. And so that is the exception here.
Disciplinary.
Yes. Mail voting on disciplinary matters. So the other part, there's two parts to the Administrative Procedure Act, and they're sort of two different topics, but they're part of the same piece of law. One is the portion that I was discussing that relates to regulations. The other is the adjudication provisions. And all of what we do in disciplinary decisions are part and are governed by that procedure. I mean, it sort of starts with, here's how an accusation is filed with the Office of Administrative Hearings. They have to do a notice of hearing. They have to, and it goes through really all the requirements. The section that we're used to dealing with the most there is Government Code 11517, which is the provision that lays out how the board responds to a proposed decision. And we can adopt it, we can reject it, order transcripts, do our procedure there. We can send it back to the ALJ. So that is all, that whole process down to reconsideration and petitions is all a part of the Administrative Procedure Act. But there's also a provision in the APA that says that these are the default rules, basically. And boards or state entities and departments can supplement or override some of those rules in statute with their own statute. So I believe our board we have our own statute on how petitions have to be filed. So we would be following those rules and when they can be filed. We would be following those rules rather than the default in the Administrative Procedure Act.
You spoke about the provisions that allow for proposed decision vote, but also, does that include stipulated?
Yes. Yes. All of that. Well, a stipulation is we're going to settle the case, and we're not going to continue to follow this process where there's a hearing and a proposed decision and all of those items. But yes, that's all governed by, and there's provisions in the act that sometimes these aren't used, but the ALJ can require a mandatory settlement conference. They can all get together, and those usually happen behind the scenes with your executive officer, your deputy attorney general, the respondent and respondent's counsel, and they can work things out. But at times, if an ALJ sees a case, good ALJs may look at a case and say, why are we doing this hearing? You guys really should settle this. I'm going to call you in, and I'm going to see if we can settle this without doing a 10-day hearing on X, Y, and Z. So similar to a court process, that happens there. Okay, no proxy votes. Can't give your vote to another board member and say, vote for me, please. Okay, and then serial meetings. So this is a good topic. Where are we at? Anyone need a break? Yes? Well, why don't I go ahead and do serial meetings, and then we'll take a break. Is that okay? Okay. A serial meeting is a series of communications between board members that involve 3 or more board members. It constitutes a meeting of the state body. And where this comes from are situations where, I think more in local government, the board members will let's see. So let's say I'm a board member on your board. I call Alicia and I say, I really think we ought to introduce a bill that does X, Y, and Z. What do you think of that? Okay, great. Now I'm going to call Sam, and I'm going to ask the same question. Sam, you should really talk to Alicia about this too. And you talk to Alicia, and Alicia tells you, you should really talk to Karen about this. and then you talk back to me about it, and I call Tanya, and we've had a meeting. We've had a meeting, basically in a legal meeting that has not been noticed to the public, and the public has not been invited to. We've violated the APA. So there's nothing in the APA that I think there may be some mention of serial meetings in there now, but this developed in the context of litigation of bodies trying to get around the requirement to do their business in public. And what court said is simply you can't do that. So we don't call a serial meeting. The only time you'd have a serial meeting issue come up is usually in litigation. And it can invalidate the decision that was made by the body because we violated the APA, it wasn't done in public.
So in your example, your first call was okay, like I need a sounding board. When you think about it, that's okay.
Yeah.
It becomes illegal with the third person.
There's a fine line that some people sort of try to walk. But at some point, if I'm calling everybody and asking their views on this, even if I'm not sharing them with each other, at some point we're having a meeting. And really, that I would not recommend doing doing that with more than one board member. If you're going to have a big substantive discussion, which you can certainly do, I just wouldn't recommend doing that. On the other hand, if we're talking about scheduling a meeting, there are some things that are just not, is it really a serial meeting for the president to call the members and ask if they're available on next Tuesday for an emergency meeting? No, I really don't. I don't see how that's a serial meeting. There's nothing being discussed.
How about talking more about professional, basically learning more about what is appropriate, let's say, technical treatments, understanding those type of,
Yeah.
can you talk to multiple members or?
Yeah, I think you could. But if it's getting into a discussion about the issue, then you don't want to have a discussion. If you are asking about, let's say, dry needling, which is something I could learn a little more about, and you ask one board member about it, and you're having another discussion with the board member, and they bring up dry needling and you talk about it with them a little bit, I think that's fine. What you don't want to do is start saying, well, I had this discussion with Alicia and she said that she's in favor or not in favor of this, and here's why. And you talk to another member and you tell them what Alicia said, and then they give their view, and then you go back, and that's where we get into a serial meeting. If we're having a substantive discussion, especially if the board's going to take action on something. I'm not saying we can have serial meetings on things if there's no action going to be taken at the meeting, but does that answer your question? Great.
So I'm running into that one, I attend the federation meetings.
Yeah.
I'm a public member, so I wanted to understand some of the technical issues.
Mm-hmm.
I want to bounce ideas around to the
Yeah.
professional members.
And actually, we have a little example coming up about this, but my recommendation, and I think what a lot of boards do, is when they have a new member, professional member or public member, but certainly you bring up a very, very good point in terms of public members learning the profession and learning more about what physical therapy is. Though a lot of boards will appoint sort of not appoint, very loosely here, informally appoint a sort of mentor for a new board member. And that way they have one person that they can go back and forth with and learn about the profession, discuss those issues openly and freely, and you don't have to worry about having a serial meeting. But I would never discourage members, even public members, from having those kinds of discussions. Now, if it's getting down to where you don't want to go is, oh, that's really interesting. I disagree with that. I think we should introduce a bill, and instead of doing X, Y, and Z, we should do A, B, and C. What do you think of that? Oh, let me call someone else and see what they. That's where you run into the issue when you're having a substantive discussion and you're wanting to take action. If you're learning about the profession, I wouldn't hesitate to have those types of discussions.
I second that. Even when during a meeting, if we're
Oh.
talking, well, during a board meeting, I seem to remember in the past, there was
certainly. Anything else on serial meetings? All right, let's take our break.
Yep.
Guys, we're starting back.
Yeah.
Are we staying up here?
No,
Oh, okay.
we're just we're being non-compliant.
Okay, welcome back, everyone. If you can grab your seats, we are going to pick up where we left off with the presentation with our Council Michael Canote. So let's tune back in.
Please, please, please.
It's flashing green right now, and it's not in use. There's a button right here in the middle, just push that. When it stops blinking, that's when it's ready to be used.
Okay, we are back to the Open Meetings Act. And all is well in the world of open meetings. It's been the same procedures for a very long time. And then came the pandemic. So this is sort of all new material here. So during the pandemic, we had the ability to meet fully virtually during the state of emergency. Based on a governor's executive order, there's actually provisions in the government code that allow during a declared state of emergency for the governor to waive certain statutes. That eventually evolved into statutory authority. There were certain requirements that we had to do to meet fully virtually. But the big point in virtual meetings is the members do not have to disclose their locations and or invite the public into those rooms. But the public also gets the ability to use the virtual format for public comment, which so there were a lot of sort of lessons learned during that period about online participation and other matters. And then as the pandemic started to wane, that authority was extended several times, and then the legislature thought through and considered a lot of these matters and made some decisions going forward. So, of course, this is California, so the solution is always to make things more convoluted and I should probably not use that word, and complicated. So now we have four distinct procedures for holding a public meeting. First is the traditional in-person only meeting, and that is what we're doing today. Second is a traditional teleconference meeting, which I think we've done in the past at times. This board doesn't do a lot of teleconferences. And the new hybrid meeting, and the new advisory body virtual meeting. And this was all done in a trailer bill, but I'm going to spare you all the citations and statements about that and just try to go through how these new procedures are going to work. So traditional in-person meeting, obviously all the board members are physically present at one meeting location. The meeting is not required to have any sort of virtual option. The room has to be open to the public. Although you can include a virtual public comment for the public to both watch the proceedings and participate through WebEx, or there's even just a teleconference service. There's different ways that can be done. Members cannot appear remotely, but staff may do so at the discretion of the board president. These rules really only apply to board members. I'll share an experience recently. I had a board meeting last summer in San Diego, and I woke up, the day before the meeting, I woke up with a little bit of a sniffle, and I thought, maybe I should take a COVID test. And of course, I was COVID positive. So I did an entire meeting as a sort of disembodied head on a computer, and I was still the best person to do the meeting. My office would have sent someone, but there were some issues that were being discussed that I needed to be there for. So that worked much better than I was expecting it to. So the meeting may be webcast. To the folks on the webcast, hello. We are webcasting today, but that is not a requirement. But that also does not provide the opportunity for public participation. But it is a great way to give the public the ability to view the meeting, and the public can always provide written comment before or after the meeting, and can ask, or can come to a next meeting and provide public comment on that. The traditional teleconference, only audio is required. All board members must attend at a public location. All physical teleconference locations must be noticed with the meeting at the agenda. I talked about this a little bit early on. Every location must be open to the public, and here's a couple sticking points. At least one board member must be physically present at the specified location. We have to do matters by roll call votes. Here's the really sticky part. If any teleconference location becomes unavailable or the member does not appear, the meeting must be canceled or must go into recess until the access to the space can be opened, until the board member is present, and until the phone line, video line, WebEx, whatever you're using is up and running. It is almost a legal fiction that this meeting is occurring in person in different places at once. So that's always helped me for whatever reason. It's this sort of simultaneous meeting that's happening in different locations around the state at once. Any questions so far? Traditional teleconference. Okay, regional teleconference locations. So, first of all, let me just say, you're not going to find this in the Open Meetings Act anywhere. And this is something that I think some other folks have do. I don't know quite how original it is, but this is something that your board council made up. And the idea here is to do a traditional teleconference where all members can appear virtually in a matter that minimizes travel and minimizes the risk of having to cancel or adjourn a meeting because of the loss of one of those locations. And I've had a couple clients do this very successfully over the pandemic. And here's how it works. You have 2, maybe 3 teleconference locations. You have one in Sacramento, you have one maybe in the Bay Area, and you have one maybe somewhere in Southern California that is convenient for all the members who live in Southern California. The advantage of this, well, we'll talk about the other new meeting types, but the advantage to this over the meeting types is you don't necessarily have to use WebEx. You can just use audio, and well, I think you can see it can limit travel, and it limits the number of locations, so you don't have one member showing up at a place and the risk of having to cancel a meeting because you're missing one member. And it depends on the size and, frankly, demographics of where your board members live. So it's just sort of an example I wanted to put forth of how you can use these, and there's nothing wrong with that. I mean, that all is very much supported by the teleconference. You can have multiple members at one teleconference location. Okay, the new hybrid meeting option. And honestly, the first line is sort of the sticky point. A quorum of the board must be physically present at one physical location. Members who cannot attend due to a disability may count towards a quorum, But it has to meet the definition of a disability in the APA, in the ADA, and the state laws that mirror the ADA. And it has to be approved by the body. They have to also state the general reason for it. That can also happen during the beginning of the meeting. So if that becomes an issue, that's something I'd be discussing with your executive officer and working on that beforehand. And hopefully that's something that would happen and be arranged beforehand. But it can happen at the beginning of the meeting. Unfortunately, it does not include the definition of a disability as a permanent disability. I don't know, I sort of had it in my mind that the legislature was thinking about COVID here, but that is not the way the statute was written. So COVID is not a permanent disability. It's a temporary disability. Okay, members in excess, and this is where it is helpful. Members in excess of a quorum may appear remotely. So if you have a member or two, you have a smaller board, so it's less helpful here. But if you have a member or two who would like to be part of the meeting, but perhaps they're out of town, they want the ability to, it gives those members above a quorum the ability to appear virtually and participate as well, and to not have to notice their location and invite the public into you don't have to do a public location for that member. The public is, but again, if you lose a quorum in the room, you don't have a quorum anymore. They can't help you.
So those that are attending remotely are not voting. They can't take a vote.
No, they can.
Oh, they can.
They can participate fully. They just don't count towards a quorum unless they have a permanent disability that precludes them from attending in person. Then they can count. See, again, it's unnecessarily complicated, but that's just my opinion.
So if we had 3 board members present and one had a documented disability, they could be virtual and that could count toward the quorum?
Correct.
Okay.
And the only way you can do this is if you have a member with a disability. Help me understand the opportunity for this hybrid that does not need to have public availability at the remote site. You're saying that, right?
Well, no, it can be used, but you have to have a quorum in the room. The ability of someone to attend remotely who has a disability, they're making an exception to that. So they can count towards the quorum.
Got it. Okay.
So then you would have 3 people in the room. You would have your person who can't attend due to a disability, discloses the general reason for it, and it doesn't have to be a long explanation, very general, and it's approved by the body, then it's as if they are in the room with you, and for purposes of a quorum. But those members that are just appearing virtually, I've not had the disability thing come up with any of my boards. It's usually, you have members appearing remotely who are in excess of a quorum because for whatever reason they're not able to travel, and it can certainly invite participation from folks that wouldn't have been able to make the main meeting.
Okay, so just here we have a quorum today, and if we had sent out the fact that this was going to be a hybrid meeting ahead with our agenda 10 days before, one of our or both of our members that are not here could have been hybrid individual where they are even without a disability, right?
Correct.
Okay.
As long as
Not that they are available right now, I'm not indicating that. But I'm
Yes.
saying they could if they wanted to participate. But
Correct.
that would have had to been determined ahead of time.
It can happen at the beginning of the meeting.
Okay.
But that's something I think your staff would want to discuss with legal counsel and sort of get the green light. Might want to discuss it with the board president. The other thing is, my first thought is that people can be fighting over who gets to be virtual or not, and those type of decisions at a board are always within the discretion of the board president. So, Madam President, you get to decide who has to come and who can stay home. You know, so the next point here is the public has to be allowed to participate virtually. And just briefly, members must keep the members appearing virtually have to keep their camera on unless there's technological issues so if you have really slow internet and you know, at times you're able to turn your camera off, then perhaps it's good to turn your camera on when you're speaking. But they made that, I think the legislature put in that provision such that if a member loses video connection, you don't have to, potentially don't have to cancel the meeting depending on how that is working. Madam President.
So in the event that a member's camera is turned off, not due to technological issues, then what?
I would say, Madam President, I said, and I'd say, Dr. Rubina Amen, I see that your camera is not on. Can you turn that on, or are you having issues? And you would potentially say, you know, I don't know what's going on. My internet is really slow. Everything keeps freezing up. I'm having, and that's the point where we say, okay, you can leave your camera off and just participate through the audio connection. You know, off the cuff here, this is the way I view this meeting option. If you're going to have public participation via WebEx, I've been advising clients to notice the meeting in this manner because it gives you the option to have members virtually. You're not required to. But if we notice this option, we do have to have the public participation option, and I think it contemplates that that's going to be like a WebEx or Zoom format where you have both audio and video. So again, a lot of times my advice is even if you don't think you're going to have members attend virtually, as long as you're doing the WebEx, there's no reason to not notice it this way. And then, you know, at the last minute, you have a member who has a death in the family, they have COVID, or they have other issues going on. They can still appear and participate in the meeting and not have to attend personally. So I like that flexibility. And again, as I said when we started, a lot of these rules, I mean, they certainly apply to us. If you ask me my opinion, the legislature was thinking about other types of committees and bodies than professional licensing boards. But certainly, I think there is still a preference out there for in-person communications and the value of that in a board meeting. So that's something that's more about the board dynamics. But it seems to me that during the pandemic, I at one point had a large number of smaller clients, and so I saw a lot of these meetings happen. And if you have a critical mass in the room, there can be a discussion. The president can run things like a normal meeting, and then the people online who want to talk raise their hand. They're recognized in turn, and it flows much differently and much more organically than a meeting where everyone is virtual and you're trying to, the board president is trying to recognize folks and have discussions, and it can get cumbersome and long during that process. Any other questions about the new hybrid meeting? Madam President.
Quick question. So the public must be allowed to participate virtually. Not this board, but I've been in other meetings. Is there a time frame set for the public to be allowed to participate?
It'd be during public comment. And the way DCA is handling that is they have members of their solid training team who are moderators. And we did that. Yeah, we did that during the pandemic and they facilitate the online public comment for us So the way it works is if it's a hybrid meeting, we would say, you would say, okay, let's move to public comment. Are there any comments in the room? Seeing none, moderator, would you please open the lines for public comment on WebEx?
Yeah, let me be a little bit more specific
Oh,
in
yes,
my
ma'am.
question. So so you may have 50 people who want to comment, but of course, you're not going to have that much time. Is there a limit? Yeah.
The board can do that in its agenda.
Okay.
The board can do that. That's the mechanism to do that, is in the agenda. And you can sort of limit it to a certain, I don't like those. Some boards will say that public comment for this item altogether will be limited to a certain period of time. I don't know, because that seems to me that could exclude people. But what are more common are limits on each person. And so they'd be given 3 to 5 minutes perhaps. And then the moderators have gotten really good at this. They give a 30-second warning, and because it's a virtual option, you press mute and you're done.
Okay, so my
Dr.
question is, so you said, I haven't been a part of this board's virtual
Right.
before, so I'm trying to understand. It's a WebEx that if you're doing a written comment, you would have had to send in on the agenda item to our board, and then it would be read at that time. But if you're doing a public comment online, it'd be like you need to speak it. There's no chat, right? You need to speak it.
Actually, there is. Generally, I think they want the public to not use this, but they open what they do. Okay, if it's written comment that's received prior to the meeting, reading it, I would generally do that, or the board president could do that, and then you say, okay, we public comment, none. Okay, we received this public comment, and then
On
you
this
just read it.
agenda item.
But when they open public comment, they open something on WebEx called the Q&A, and so there is an ability for members of the public to write something. Usually, it's help. I can't. How do I get off mute? Or things like that. Or they can also raise their hand. They can raise their hand in there. But I have seen meetings where individuals have written a comment into that Q&A, and in that case, the moderator will read it.
And all comments are not, they're not anonymous.
Correct.
You have to
You're speaking
have
in a
logged
public
in.
meeting.
Exactly.
Yeah.
To that point, public comment, they do not have to identify themselves, correct?
Correct. Correct. You do not have to, under the Open Meetings Act, identify yourself. Some boards will ask for, they will have a sign-in sheet. You don't have to sign that. They can't be required to do that. Interestingly, also, members of the public can come to your board meeting and they can record the entire proceeding. And that's specifically provided for in Bagley Keene.
Similarly, when we have public comment, board members themselves should not necessarily or should not ask for the person to identify themselves?
They don't have to, correct. Correct. Public comment really should be just that. Thank you for your comment. Boards, it can be very problematic to start engaging in a colloquy with a member of the public about a certain issue. Members of the public don't have the right to walk in and ask questions and demand answers from the board. Even if that occurs, my advice to the board president is you say, thank you for your comment. Next.
Yeah. And so some members of the public will come up and say, my name is, I'm representing this. But for those who don't, I guess, let them make their comment and say thank you.
Yes, yes, no, we don't have the ability to, I mean, we could ask them, but they don't have to provide that information. I mean, I think that depends on the context. Yeah, but they don't have to give their information. And again, I would not advise you to have any question back and forth with members of the public. I mean, there are things that are very sort of innocent enough. You have a good relationship with your professional organization. They usually come and, you know, you can go there, but what I say, the word of caution is, if you get into a question and answer with a member of the public, and then you have another member of the public stand up, you're going to have to do the same thing. It's hard to justify doing that for one party and not another, because it looks like you're showing favoritism towards a member of the public or a particular view. Ready to keep going?
One innocent example would be Q&A with students, right? So one innocent example might be Q&A with students.
That is not public comment. You have agendized that as a question and answer
Okay.
portion of the meeting. So it's almost as if you've invited the students, the same way we invite presenters to, I think we had a great presentation last time on the JAM. They are sort of in the role of presenters. And then at the end, we would still ask for public comment. I mean, it's probably not going to be relevant here. But I think that's fine. And if there's a topic that comes up, I would basically, I mean, if you have a student come in and say, I don't understand why dry needling is illegal in California, and board, what are you going to do about that? I would say, I would stop, and I would say that's not within we haven't agendized that topic in discussion. We can't have that discussion here right now. If the board wants to put it on the agenda for a future meeting, we can do so and have a discussion about it. Okay, moving on. The advisory body virtual meeting. So you have to, this enables certain state bodies to have a fully virtual meeting. But the sort of the rule of thumb is an advisory body doesn't have the ability to really make any decisions. If the only example that's really relevant is if we had a 3 or more member committee that was going to have a meeting. If we had standing committees, this would apply. But if we had a ad hoc committee that was put together to discuss an issue, and you wanted to sort of get into the discussion about the issue in the public meeting, you can have that fully virtual based on this option. There must be, however, a physical location staffed by the body where the public may attend. You don't have to have a board member there like you do with a traditional teleconference. So that is sort of sort of contrasting with the original, the traditional teleconference. That's sort of one of those contrasts. But you have to have a spot where the public can come and be able to view the meeting and provide public comment and participate. And the agenda must designate members who will attend virtually, and members must keep their camera on, again, unless technological issues require that it be turned off. And generally, these virtual meetings are fully virtual meetings, and so my advice to clients has been to include a line that says all members will attend virtually, which satisfies the requirement to identify who will attend virtually. Any questions there? This is much more helpful to bureaus and the boards that have standing committees that meet regularly. They can use this item, this manner. Okay, example 1. I'm going to go through just sort of a few examples to talk about some of these issues. We can have as much discussion as you'd like on these. And the first example is the board president sends an email to all members of the board that provides. To all members of the physical therapy board, I have a great idea for continuing education. I think continuing education regarding office uniform colors would really improve the public image of our profession. I have attached a position paper I prepared on this. Could you please read it and email me back on whether you will support this proposal? Anyone see any problems with, does this continue? Oh, it does continue. What is the problem with this email? Serial meeting. Right, this is exactly the situation, the reason that there's a prohibition against serial meetings. This is an example of a situation where they basically have the board meeting and you walk in and say, oh yeah, and you might have a small discussion and ultimately the meat of the meeting and the real discussion happened out of the public eye. What should you do if we receive this type of an email?
Reply all. Reply all and say this is not appropriate.
I think the better answer is to email legal counsel or the executive officer, because you're even in discussing whether or not it's appropriate, you're having a serial meeting.
The executive officer can talk to the person who sent the email.
Yeah, I would.
Or staff.
Yes, I would recommend, but I would recommend also informing legal counsel of this, because if this happened, and of course it would never happen with you guys, I would probably step in and I would reply all. And I would say, members, looking forward to a discussion about this at the meeting. We can agendize this. And I'm giving legal advice, so then it's different. We cannot have this discussion via email. Please do not reply to my message, to the original message, and look forward to having a discussion about this at the meeting. That's how I would handle it. But alerting the executive officer can, yes, I would not be responding to that email in any way.
To that point, if the EO or the president wanted to put something on the agenda, how do they communicate that to the individual board members?
That would generally be done by the agenda itself. So the president has the ability to, we always, and most boards do, have an item asking for agenda items for future meetings. And that's one way you can put something on the agenda. But the board president sets the agenda for the meeting. If your board president wants to add 10 topics of discussion, the board president can do so.
And as individual board members, going to the president and asking
Correct.
to put something on is not considered a serial meeting. It's-
Correct. And just to close that loop, when we get into discussion, when there's a suggestion for a topic for a future meeting, I am always listening very closely, because you can only discuss that to the extent that you're deciding whether to put it on the agenda. And it's so natural, and it just happens. Board members say, I think we should put a discussion on dry needling on the agenda for next month, and here's why. And then they start going through their views, and they're sort of they're explaining why they want it on there. A little bit of that is fine. To say, I think this is an important issue facing the state. This just happened. I think it'd be good for us to talk about this. If they go, and here's why, and then they start having a substantive discussion about it. That's the point where I'm going to jump in and say, we're off the agenda, and we'll look forward to a discussion on this when we take up the item next time.
I feel like you're saying you want to be in all of our discussions.
Of course, always. Well, but truly, and perhaps this isn't said enough. I am your board's attorney. I'm your staff's attorney for all matters except disciplinary matters. I am your attorney for those disciplinary matters specifically, but I'm also your collectively I'm the board's attorney, and I'm also you also all have individual attorney-client relationships with me, with your board counsel. To the extent you have issues, if you have questions, anything about a disciplinary matter, or the workings of the board, you're always welcome to contact me. But if you also have personal issues in terms of wondering whether you have a conflict of interest, or there's just something you want to talk to your board counsel about, you always have the ability to do that. And unless it's relevant or it could lead to a recusal, that's always a confidential discussion between us. Okay, I just went on a tangent. I'm going to pull myself back. What if an analyst of the board disseminates the proposal on the president's behalf and asks each board member if he or she will support the proposal? No difference. No difference. You just have a member of staff facilitating a serial meeting. Okay, example 2. You and 3 other members of the 7-member board are at a table together during a multi-state physical therapy conference. After talking about the meeting location and local restaurants, one board member asks if the other members will support a bill to help a nonprofit group that provides counseling for physical therapy patients who suffer from phobias related to physical therapy. So we have some fun examples here. What should you do and not do in a situation such as this? Tanya has the mic, so.
Because you were smiling at me, so I smiled back. So this is, well, I'm not going to have that discussion, and I'm going to contact you
Very good.
immediately so
Very
that
good.
you can handle this.
Very good. Or, if I'm not there, if there's a member of staff, you can certainly do that. If I am there, I need to pipe up. And I do that quite a bit. They will remain nameless, but I have one board that I had to keep. They would recess the meeting, they would go into lunch, and they would start talking about board business. And that's not something that can occur.
So I'm breaking down this scenario. Meeting location of the multi-state meeting they're attending and the restaurants of that, or are we talking about a future meeting of the board?
Well, that's included, I think, to elicit this type of a discussion. There are certain very innocuous things that board members can discuss it, amongst even a quorum of the board. The discussions we had this morning about parking, that's not really board business. A discussion about what restaurant we're going to go to for lunch during the board meeting, that's not board business. That's eating and parking. And again, the danger can be then that can turn into a discussion, which is sort of what the example was trying to elicit. That can turn into a discussion on other things. So it's really anything related to board business. But you can certainly talk about, it's really good to stay personal. And also, I think it really engenders cohesiveness, and you get to know your colleagues on the board, and you get to know each other. You can certainly say, hey, I got a promotion at work, and you can talk about I need to be careful here. You can sort of talk about yourself, your employment. This is what I love about physical therapy. I love helping people. I love when you get to, and I think we should really start as a board promoting more, I'm just going to use your example, outreach for high school students. There you've crossed the line.
So, disclaimer, this did not happen, but as a public member, I'm glad Sam brought this up. As a public member, say you are, at lunch and you're with other board members, and you're new, and they start this conversation, and it just flies over your head. But then you come back into the meeting and you realize, oh, that just happened. So then what? I mean, I know still
I'd advise you to
share it, but then what?
I'd advise you, if it happens and it's within more than one board member, or excuse me, more than two board members, then I'd recommend that you just discuss that with me and we'll decide what we do or don't need to do. Some of those discussions can be very innocuous, you know. Oh gosh, yeah, we're taking up that matter today. Gosh, that's going to take a while. We're going to talk about dry needling today, and here's what I think of this. That is well over the line, and you are almost squarely in the next example. You are now a veteran of the board, and a newly appointed board member reaches out to you to learn about issues facing the board. This also goes to Mr. Q's question earlier. Does the Open Meeting Act preclude a new member from speaking with other members to learn about the issues facing the board? No, it doesn't. It does not. But again, you want to be careful. I like the example of new members or public members having sort of a mentor. And I think that can be great, because the reason that we have on boards professional members and public members are to get both perspectives and allow the public members to bring the perspective of consumers. And really, your board functions very well. I mean, at times in closed session, I'm asking the professional members questions as well, because I'm a lay person. I don't practice physical therapy. I know quite a bit about it now, but there are particular practice issues that I just really couldn't conceive of. Okay, moving on. How are we on time here? I can't see the clock. Okay, great. Conflicts of interest, disqualification, and abstention. Disqualification occurs when a member is ineligible to act on a specific matter before the board, generally because of an actual or perceived bias or conflict of interest usually based on a financial interest. So it's biased, or there's specific laws in the government code that talk about what is a financial interest. And we can get into discussions about some particulars about that if you'd like. But I'll run through this, and there's some examples I think that'll help there. Disqualification is also sometimes referred to as recusal, and that's generally how we talk about it. But truly, what it means is because of X, Y, or Z, the member is disqualified from participating and must recuse themselves. At times, I have discussions with board members who maybe there's a petitioner coming before the board. Maybe they know the person in some way. And again, there it matters. What's critical there is the ability to not be biased, and to be able to be fair and treat the person the way they would any other licensee that's coming before them. And I think the line is generally not whether there's a personal relationship. If it's your former business partner and you work together, that's very, very clear. If it's, let's say you work at Kaiser San Francisco and you're a physical therapist there, and there's 50 other physical therapists there, and the petitioner is one of those physical therapists, but it's not someone you know at all. There we'd have to have a discussion. And I should not have brought up that example, because there could be a potential financial interest there, but I don't see that. Now, if it was your best friend, your office buddy, that's when you certainly have to recuse yourself because of those types of issues.
Former student?
If they had you for physical therapy theory, and it was a classroom of maybe I'm making up a bad example here, and if it was a classroom of 150 people, and you didn't have any sort of special relationship, they just went to one of your classes, that I think is not going to be, that's not going to disqualify a board member from participating. Dr. Rabina Amen and I have discussions at times about, she has students that she works with regularly. She goes sees them, she mentors them. That would be, I think, a situation where a board member would want to recuse themselves.
If you recuse yourself and you're barely at quorum, how do you handle that?
You know, you guys all should do my presentation for me, because I think that's the next example. So give me one moment. Give me one moment. So really briefly, the difference between a recusal and an abstention, or disqualification and abstention. Abstention occurs when a member chooses not to vote on a particular issue, even if the law allows you to participate and vote. And we'll get into more detail in a moment. Disqualification is mandatory, while abstention is voluntary. Conflicts example 1. Your spouse owns a private educational institution that offers board-approved educational programs. And an item on the board's meeting agenda concerns a possible change to the board's regulations that would essentially find that your spouse's program no longer meets the board's requirements for continuing approval. May you participate in the discussion and vote on the matter. Anyone want to take a shot?
Yes, you can participate.
Well, I think, so there's sort of two issues that this elicits. First, if your spouse or close family member has a conflict of interest, best way to think about it is you do too. I mean, especially with the spouse, because California is a community property state, and half the income from this business is technically the members in terms of community property. And this is such a change that it would put your spouse out of business. Now, that's contrasted with every little change we make to continuing education is not going to have that impact. It would have to be something like changing the type of providers, or, I don't know that I can go much further into that example. Do you follow?
What if you hate your spouse and you want them to lose it?
It's all about, lawyers like to talk about Mr. Green. Have you ever heard Mr. Green? Well, when a lawyer comes into a courtroom and their client hasn't paid them, the little short way of telling the judge that, I want to get off this case. I want to get off this case because, Mr. Green just hasn't showed up. I've looked everywhere for him, and he's just not forthcoming. So really, it does relate. These are financial interests that these relate to. If it's your ex-spouse, different situation. If it's your brother, sister, mother, father, child, that's probably going to still be considered a financial interest. But that also is a good example of a situation where there might be something that's close to the line, or perhaps you're not quite disqualified, but you're still thinking, I just think this really looks bad for me to be voting on this. That is an abstention situation.
So like perceived bias,
Yes. But again,
even if it's not on your Form 700.
correct. That's a situation where one might want to abstain. And we'll get, there's another example that gets more into that too. So let me jump. Okay. Similar facts to the last example, but the board's attorney is of the opinion that there is no legal basis for disqualification, but you still feel uncomfortable about participating in the decision. This may occur if you feel you cannot separate your personal interests from your duty as a board member, or you feel uncomfortable about participating in the matter for any reason. In this situation, you may want to abstain from casting a vote. Unlike a disqualification, this does not preclude you from participating in the discussion. Oh, I left out a very important point. When a board member is disqualified and recuses themselves, they must physically leave the room and not participate in the discussion. And I mean, I think the sort of idea is whether they speak or not, the other board members are sort of sitting here with a member who's recused themselves because they say they have a financial interest, and there's that potential to maybe have a different discussion or not want to offend the person. I think that's sort of what's behind that issue. Okay, but here, can the board still discuss the item? Yes. Can you vote on the item? Yes. Yes. Abstention is voluntary. Okay, here's where we get to the question that came up before. Presume that only 4 members of the 7 seats that comprise the board are filled, and the remaining 3 are vacant. Since the present and participation of 4 board members constitutes a quorum, the board schedules and holds a public meeting. During the meeting, one of the 4 board members, which is the quorum, states that she is disqualified from participating in an agenda item because she has a financial interest in the matter. Can the board still discuss the item? You don't have a quorum on that item. What I would recommend that you do in a situation like that is to postpone the item to the next meeting. Or if you have grounds for it, you can call a special or emergency meeting. But again, the board cannot discuss the item at all. And that's one of those situations when the item came up, I would have to be careful because at times it may invite a discussion about, members, when the person leaves, the members may want to try to discuss. Actually, we would probably handle that differently.
If you're talking about there's no ad hoc issues. So if ahead of time someone saw that this issue was coming up, they could contact you before, and then at the beginning of the meeting, if it was decided they should probably abstain, well, not abstain, but
yes.
recuse, then the president could adjust, or they could communicate that at the beginning of the meeting, that we're going to be pushing this. Does it have to be discussed? Why?
If you can do it before the agenda comes out, then that's very, very helpful. So you're not doing it on the fly and there's not something on the agenda that can't be discussed. But in terms of, as a board member, you're trying to determine whether or not you have a conflict.
Yeah.
That is absolutely a situation you discuss with your board counsel. That's a confidential discussion unless it goes a different way. I had one of those discussions with a board member during this meeting. I won't say who. But that is one of those situations where that's how I would handle it. Give me a call, unless it's and I mean, sometimes it's very obvious.
But we may not know the entire agenda by the time it comes out. So if we see something,
Right.
it might need to be addressed with you first, and then
Right.
would you tell the president, or would we?
I'd invite you just to contact me and I can handle it from there. I'd probably talk to the executive officer and again, we'll have a discussion about what it is and what you're comfortable disclosing or not. Because we can just come out and say, I mean, if it's something that a board member didn't want to discuss, like perhaps there's a petitioner that, there's, who knows? That was a personal relationship and there were problems. And but again, my point is that you can always have a confidential discussion with me about whether or not you have a recusal, and that doesn't have to go anywhere else, presuming that you don't. Okay. Oh, I am going the wrong way. Let me just make sure. Okay. Professional association relationships. I think this is helpful to call out separately. Professional members of the various entities within the Department of Consumer Affairs are often members or even officers of professional associations. That is a very natural thing. Sometimes these dual interests may clash, however. While there's no prohibition against board members serving as officers in professional associations, this is where you must ask yourself, must I disclose myself or abstain, must I disqualify myself or abstain from participating in a particular matter based on these dual interests? And here's our example. The Physical Therapy Board is considering sponsoring legislation that would modify the Physical Therapy Act. Not your California Physical Therapy Association. The California Association of Most Excellent Physical Therapists adamantly opposes what the board seeks to do. You're the president of the board. You're also president of the association. The association's board of directors are pressuring you to get the board to drop the proposed legislation. How should you respond to the association board of directors?
Assertively.
Meaning you would say, whoa, I
Yep.
can't have this discussion.
Absolutely.
That's absolutely right.
Yeah.
What should you do when the agenda item is taken up for consideration by the board?
Recuse myself.
I think this is probably a situation where you need to recuse yourself. I mean, the way the question unfolds certainly leads to that because you have a conflict based on your duty to the board of directors in the association and also due to the board. You recuse yourself. There's a lot of different schools of thought between different boards and lots of folks about whether it's appropriate to have a board member, especially being president of the board and president of a professional association. It happens. It's not illegal. In and of itself, it is not illegal. But when you get down to those sort of disqualification issues, I have to say, it doesn't seem like a good idea to me. Being a member of a professional association is one thing. Participating on a committee is another. But when you're in leadership positions, especially if you're in leadership positions at both a board and an association, I think you're asking for trouble to some extent. I don't want to seem critical of any appointments made, but that is really a matter for the appointing authority to decide and discuss when they make the appointment. But if you're a board member and you're thinking about becoming an officer of an organization, it's probably a good discussion to have with your legal counsel. The answer will be the same. There's nothing that prohibits that. Telegraphically, that could look bad, but, perhaps not. And I think it also can depend on the relationship between the organizations.
And I think it's very possible for someone who's very active in their association to be able to wear their PTBC hat appropriately.
Mm-hmm.
And I think our board in the past has done really well at reminding each other if that doesn't happen.
Yeah.
At what point do you have to disclose if you get another, role or position? Like if it's in the process of your current appointment or, yeah.
There doesn't have to be any overarching. There's no requirement that you come forward and at the next board meeting you raise your hand and say, I want everyone to know that I'm now a member of the subcommittee of the blah blah blah. I don't really think that that's necessary, but again, if an item comes up like this, it would be, again, I'd recommend you talk to legal counsel about it, and I'm always willing to, I had a member of another board recently who had a conflict, and my explanation was, when this comes up, you can speak up and you can explain it, or if you'd like to defer it to me, I'll say that we had a conversation. Member so-and-so has a potential conflict of interest here, is going to excuse themselves, and what I did in the meeting, actually, I made a joke, and I try to make it, and this is just my style, I try to make it not confrontational, and I threw the member out. Yes. Now you must leave. And that's part of the law, and I explained that, and yeah. I think we've covered all that. Yeah.
So you're recused, you're disqualified, you leave, but the meeting is still online and the minutes are there. How do you keep that person from having information about?
They can have information after the fact.
Okay.
But they can't be in the room for the discussion or vote on the matter, because they can influence it that way. I mean, you can sort of imagine that. You can sort of imagine this. You know, I'll pick on Monty for a second. Monty, let's say you're the board member who has a recusal, and we're starting to talk about an item. So this is what I want you to do. So I think this is a great idea. You know, there's ways you can, through body language and other things, sort of telegraph your opinion on it, and you know. So I think that's the idea about having. But after the fact, you can find out what the vote was. You can. It is all public, yes, and you can know those items. Questions? We've had a lot of questions. All right, really quick. This presentation is somewhat based on a presentation that your former legal counsel, Angelique Scott, who I've never met, did, and I just thought it was appropriate to acknowledge the plagiarism that has occurred. Any other questions about conflicts of interest, disqualification, the Bagley-Keene Act? A lot here. Is there any public comment? I'll just handle that for you. Hearing none. Madam President, I will hand the meeting back over to you. Thank you.
Oh, thank you for that presentation. Right on time. Do we have anyone here from CPTA? Oh, yes, so we will pick up and go back to 15C, California Physical Therapy Association, CPTA.
Good morning.
There you go.
Thank you. Good morning, members of the board and staff. My name is Joe Carlucci. I am a member of CPTA and the Quality Subcommittee. Tamika Island sends her regrets. She is on her way to Burlingame to set up for the annual conference, of which she hopes to see some of all of you there. But she did text me her report, so I will be reading that to you. They have ended the registration for the annual conference with almost 700 attendees, which is a significant increase from 2023, which was 430, so a good increase. The exhibit hall is sold out, and ask everyone to save the date for next year, September 2025. The annual conference will be in Palm Springs at the Palm Springs Renaissance. And CPTA membership continues at more than 10,000 members. Regarding education, the program continues to be successful, especially the Webinar Wednesday and the CI courses. Goals for this year were 3 Webinar Wednesdays each month and 1 specialty course on Saturday each month. And there have been 7 done so far this year, 2 more are expected. There were 2 full-day or multi-day courses, a goal of 2, and 3 were done. 1 in August on therapeutic exercise, and 2 in October on clinical instruction 2 and LAMP. And there are 11 CI courses, all virtual. So we've hit that, and we have 16 on the books through December. And she also wanted to say thank you to Jason, who presented Q&A with the PT board on August 7th. It was very well received and much appreciated. Regarding modernization of the PT Practice Act, work continues on this to ensure that it is current and allows PTs to practice at the level of their current education. If you are attending the conference and interested in more information, attend the Empowering Progress, Transforming the California Physical Therapy Practice Act for the 21st Century Healthcare, given by Oscar Gallardo and Dawn James. It will be the first session after the break at 10 o'clock on Saturday. Next, SB 525 update, the healthcare worker minimum wage. The CPTA submitted 3 requests for clarification with the California Labor Commission office. Last week, we were contacted by them to share that the new law does not apply to outpatient PT clinics or clinics with PT, OT, and speech services without physician services. We expect the delayed implementation of SB 525 will end sometime between October 1st of this year and January 15th of 2025. And finally, she asked to share this feedback. It is from the CPTA and Physical Therapy Board joint webinar. There are a lot of positive comments, a lot of thank yous, few specifics. Excellent use of my time. Found the open discussion most helpful to clarify aspects of the PT Practice Act. Great questions and content. Appreciated the dialogue and interaction. Great webinar, excellent interaction. Jason and Tamika are clear and thorough. Jason was very knowledgeable and helpful. Thank you for providing the Wednesday webinars, offered at least annually. Thank you to Jason and the CPTA. The questions generated good information and were thoughtfully answered. I was surprised that more people not on the call for the opportunity to interact with the board. I learned more information about the retired status and 5-year information. It exceeded my expectations, and I really appreciated the questions of the attendees. I learned important things about licensure I wouldn't have even thought of. Good opportunity to get updated on professional information. And that's her report.
Thank you. Any questions or comments from the board?
Thank you for sharing the specific feedback from those who participated in that Wednesday webinar with Jason. And I just would encourage board staff to continue to offer that as able and as invited by the CPTA. It sounds like it's very beneficial for licensees to ask these questions and get these answers and then hear the questions from others that they haven't even thought of yet, to get this information and possibly, at least for this particular group of people, have a one-stop shop to hear it all instead of trying to get information and piece it together in different places and maybe even calling the board for clarification, which is always welcome. But it just sounds like this is a successful thing for the board to continue to do as able. Yeah.
very much, and I will pass that on to Tamika. She wrote a large handwritten part, said, please share this with the board. So, yeah, she was very appreciative. So, thank you.
Okay. So I know that we have a hard break for lunch at noon? Or is there a little flexibility? Can we move on? Oh, I'm sorry. I did not open the floor for public comment for CPTA. And we just learned that. Okay, hearing none, thank you. We can keep, okay. So we are going to move on to agenda item number 17, our administrative services update.
Let me get on. Good. Sorry, I'm just getting on. Okay. Hello, my name is Liz Constancio. I'm the manager for the Administrative Services Unit at the Physical Therapy Board. I'd first like to thank the board, Madam President, and the members of the board, and also leadership, Sarah Conley and Jason Kaiser, for allowing me the opportunity to present on behalf of the board and represent the Administrative Services Unit. Quick background, the administrative unit is responsible for essential administrative and business services functions. These functions include, but are not limited to, ADA compliance, asset management, information technology, budget, cashiering, contracts, facilities, personnel, procurement, training, travel, and other operational reporting requirements. For item A, I just have a few updates. It seems to be the theme around here for budget letters, so I will keep that brief. But going along the lines with the budget letter that was issued by the Department of Finance in 23-24, it directed all the entities under the governor's direct executive authority to reduce our expenditures for both 23-24 and 24-25. And so we did do that, and we will continue to do that. With that, the administration's unit did a really good job, and so I really like to thank the staff for doing that. It came with a lot of work as far as setting priorities with office supplies and equipment, and looking at that and saying, you know, do we really need this? I mean, do we have to order that? Can we see what we have? And just going through our assets and making sure that we are just only purchasing the things that are really mission critical to the board. And again, we will continue to do that, setting priorities and working with management and leadership on those things. Moving on to travel, the same thing here. We did set priority to travel for mission critical. Sarah Conley mentioned yesterday in the board meeting in regards to outreach being one of the functions that is a priority for the department, and so we are following suit, and that's one of the mission critical items that is included in travel. Any other travel needs are being reviewed by leadership and will be addressed accordingly. The same thing for training. Training has been limited to job required training only. We are utilizing the DCA solid unit for our training needs. These costs come out of our pro rata, so it works. It's a benefit to us. Any job required training that is not offered by Solid, we will be reviewing that and working with the units on feasible resolutions. With that, I am pleased to report the PTPC employees are up to date and in compliance in their training and mandatory reporting requirements. Management is currently working on completing their continuing education requirements. Management and leadership are required to complete 10 hours of continuing education each year, and we do have until December 31st of this year to meet those requirements, and we are working towards that. Management is really good in leadership on staying in compliance with those. Anybody have any questions before I move on?
Hi, Valerie, thank you. I'm just asking, are we going over the expenditures yet, or are you going to do
No.
that next? Okay.
I'm going to do a quick program update, and then we'll go into expenditures. No worries. Personnel, the PTPC has authorized 29.1 positions. We are currently recruiting for 4 permanent full-time positions within various units. I'll let the units talk about their vacancies. One of those vacancies is our lead analyst position within Administrative Services unit. I'm trying not to get emotional talking about Alicia. Sorry. Alicia is no longer with us. She graciously showed up today for us to say goodbyes. I do want to say something about that. Congratulations on your promotion, very much deserved. She was with us for a year and a half, and even though it was a short amount of time, she definitely made a great impact to the admin unit and the board in its entirety. Her guidance and help have been invaluable, and we'll sorely miss her. It has been a wonderful opportunity and a pleasure to work with you, and we wish you exciting new challenges in your new chapter of your life, as well as the best for a bright future. And so we really appreciate that. I will miss you. Some big shoes to fill here. Our personnel liaison, Julie Tao, is currently working with management on filling our vacancies quickly. I know that that's a priority for leadership, and we will continue to do that going into the next fiscal year. For cashiering, the board had 25,962 transactions with a total collection of $7,820,808. During Q4, DCA's accounts receivable office assisted us with our accounts receivables business processes. That was really helpful. And those things included like looking at our business processes, seeing if we're adhering to the policy and procedures that are required within DCA. I'd just like to thank DCA for doing that with us. As a result, we do have some updates to make to our cashiering manual, and staff is working on that now. For ADA, I am so pleased to announce that we are in compliance, and that's with the Americans with Disabilities Act. And so what that means is our IT liaison, Vincent Azar, works with the unit staff on things that are sent over for public and on the website, and they need to meet ADA requirements, and the board is up to date in compliance with that. Asset management, for Q3, I had reported that we were working on our annual audit in regards to all of our assets. That effort continues. Vincent Azar has identified all of our assets, and now we have them on a master equipment list. So the next phase we're going into is that we will be looking at actually doing the audit part of it. You know, what's being used in the office, this is what we identified, and what's being used at home, and making sure that we're reconciling any deficiencies in that area. And so we anticipate that, as I reported before, by December of this year. information technology. So now that admin has moved over to SharePoint, we are so happy. We are actually working on our last workflow. We have a number of workflows regarding our business processes. Our last one that we're working on is our contracts. Thank you, Alicia and Vincent. They worked really hard on that. We're going to be automating our contract process. So the review, looking at the contracts and actually getting signatures, and it's going to be all automated. And so I'm very excited about that. The other thing is, I know executive unit, it was reported that executive unit is now completed. They are now on SharePoint. And then Vincent will be working with Consumer Protection Services unit next, and then so on to the other units. So we're really excited. So thank you, Vincent, for all your efforts. I really appreciate that. This project is a huge project. And he's very smart. I appreciate him. Agenda item 18B on the budget. I will go ahead and leave that to you. Alicia worked really hard on all the data that was collected for the year end and doing the comparisons. And so I thank you so much again for being here. I know you worked really hard on this information. Yep.
Good afternoon, everyone. My name is Alicia Hernandez. I am your former lead analyst for the Administrative Services. Okay, thank you. Good afternoon, everyone. My name is Alicia Hernandez. I'm your former lead analyst for the Administrative Services Unit for PTBC. Before I get started, I just wanted to thank all of the board members and the staff of PTBC for all of the support and growth in my career as your budget analyst. It has been a wonderful 18 months, and I could not have done it without the help of everyone in this room, and of course the staff that is listening out there today. With that said, you will always be considered by PTBC as my DCA home base. So this is where it all started. So thank you again for your support, and I'm looking forward to my future and my careers throughout DCA and moving forward. So I will begin presenting my last budget report for PTBC. PTBC spent 92% of the fiscal year 2023-24 budget of $7.2 million. PTCB reports at the end of year fiscal year 23-24 at $6,639,268, an increase from last fiscal year. Prior year 22-23 expenditures were at $6.5 million, and this is just a normal increase. The PTBC highlights an increase which are attributed to staff salaries and benefits, primarily due to filling vacancies. PTBC has a positive revenue collection ending the year of 2023-24 with $7.4 million, which is about roughly $165K increase over the prior year. This is attributed to increase in applications and licensing, which historically has a normalized about 5% increase year over year. Our PTCB current budget moving into 24-25 governor proposed budget is at $7,324,000. The PTCB will continue working with DCA budget office during this next galley period to finalize line items to align with a more accurate account for expenditures, which include things like general expense, travel, etc. With that said, the PTBC reports that we have no action required as it relates to the budget expenditures and revenues. Again, thank you everybody for your continued support, and I'll be back. Any questions?
I'm trying to get on here. Okay, thank you so much, Alicia.
Of course.
And we're happy to be your home base. This
Yes.
is a great place to be, to step off from. I just had a few questions just to help me understand the budget line items a little bit better.
Sure.
When we're looking at the percentage of budget spent, specifically those that are very low, like information technology, 9% of the 16K that we budgeted. Is there a reason why we would expect something to be like last minute turned in, or is that just we over budgeted for that?
Well, during the 23-24, we had the budget letters come out, so we were intended to get laptops and things like that, but we unfortunately were not able to do so. So that was like the halt in the program. So that's why you see that low number.
That was our conversation end of last year about laptop, how long you can keep it and when they
Yeah,
need
the
to be.
warranties were expiring,
Okay,
yes.
great. And then I'm not familiar with the exam admin external. Is there a reason why that's not budgeted? We had a 2,500.
The reason why we don't have a budget?
Yeah, on that one.
Yeah, there is no budget for that. We just take it off of the bottom line. We don't have any budget set aside for that particular line item. And that is FSBPT.
Okay.
And we can definitely, that's something we talked about for a couple of years now, wanting to fix, to do a hard adjustment through Galley with DCA Budget Office and designate some money in that area so that we know this is the amount, this is what we're going to spend, and this is what we have.
Yeah, because it's every year.
Yeah.
Yeah, same amount.
Yep.
And then one other question. I don't know what CNP Services Internal is.
That CMP internal, that's our consult and professional services.
Okay.
So that would be like, Sarah talked about us doing the exam, right? OPES? Is that the acronym? I'm sorry, I forgot.
Yeah.
Yes, OPES. So that would come, if we were to move forward with that, the cost of that would come out of that line item.
Great, thank you so much.
Congratulations, Alicia.
Thank you.
And, we'll miss you.
Thank you.
And I will miss you.
Thank you.
And I have a question regarding the personnel services in total cost. Are the vacant positions in the budget?
Are the vacant positions in the budget?
The money in here?
Mm-hmm.
Yes, and so whatever that is not spent, that would be considered your salary savings. So that would be the vacancies.
Okay, so how do we reconcile that when we still have 4 positions vacant, but we spend most of the money? How are we going to cover that going forward? We only have $5,400 of savings.
Let me get where you're at. On the first line item for civil services permanent?
The total, I'm looking at the total personnel services.
So if I may, Michael
Okay.
Knotes, legal counsel, the budget is the full amount of the cost for all of the positions, including the vacant ones. So you're budgeted for those positions to the extent that you're never fully staffed all the time. Then basically you end up under budget for the year, and that amount gets reverted into your next budget year.
Sam, I think you're asking that how we're going to afford it when we fill the vacancies, because it looks like
Exactly.
we're really tight already when we
Right.
have vacancies. And so that's a really good question. So we have overexpended our in personnel services, and that's just I hate to say this, but it's kind of like it's a normal thing. So when you have positions that get their merit salary adjustments through their contract. So let's say, they would get like a 5% increase or a 2% increase. When we're building the budget, those things, some of those things are not necessarily accounted for. They kind of resolve themselves over time. Does that make sense? And so it kind of balances out at the end. So it's not like we won't go into the development of the budget and we say a staff person is going to get, they're going to move up a range. There's A, B, and C. So they're going to move over to B range. The budget does not account for that. And so we would go over in that aspect of it.
Okay.
And so we would have to adjust in other line items, and that's where the monitoring comes in. We're thinking, okay, this is what we're projecting to spend. It looks like we're going to fall short in that area. So let's look at these other line items and make sure that we're meeting that. We're going to take that money and we're going to redirect it to personnel so we can cover the cost.
Got it. So I'm assuming that the budget process for the next fiscal year will pick up some of that consideration, right? Meaning that now you are moving into 24, 25, you're expected to fill in 4 more positions, and then you would do your line item adjustment to try to, because I'm assuming that your
Realign.
total is capped, but then you will make your adjustments to push the salaries budget up, and then some other line items will be mopped up and to backfill that.
Yes, so the adjustments will come in not until 25, 26. The budget has already been, proposed budget has already been developed for 24, 25. What the board and bureaus do, so for us, we would be going in and we're going through Galley, it's called Galley, and we're looking at it very closely, and we're providing a more realistic account for what our budget needs are, what our costs are going to be, what our revenues are, and we're saying, okay, this line item, this is where we need to be. It's not there, we really only have $15,000, but there's another line item like information technology, I know I'm not gonna spend that, because based off of workload, I know I'm not gonna spend that, so I'm going to move it, and that's what we do.
Got it. Thank you.
And correct me if I'm wrong, but I believe when we get position authority, we get that, the amount we get for those positions is about mid-range because they don't necessarily account for any merit salary adjustments. So it is expected that we may overexpend our personnel services because they're not going to give us the money at a top range for a new position. And then you end up, the view is kind of you end up balancing out because you may have turnover with new staff. The board does not have that so much, so we tend to overexpend, I think, more regularly because our staff stay.
Yes, that is correct. Yes,
Got
thank you,
it.
Sarah.
Thank you. Thank you.
Any more board
Question?
comments, questions?
Yes, thank you both for your reports. Thank you for being here, Alicia. You didn't have to, and we appreciate you coming.
Of course.
She loves me.
It's mutual. Liz, thank you for your briefing report, your briefing paper. On the analysis section, the second paragraph, it shows there was a $26,469 decrease in initial applications for Q4. And I know that we're constantly talking about the proliferation of programs and how that creates more work, but there's also anticipated increased revenue, and I'm wondering why we saw a decrease in Q4 in initial applications. I'm not even sure if that's a question for you or for Sarah or for another unit.
As far as for budget, sometimes it's just a matter of timing. I mean, depending on when the examination is scheduled for, we can see like when we're receiving the hike in applications come in and then our revenues increase. Again, I think it's just, it's timing for us. And Sarah, if you can expand on that, I don't know as far as applications, what would be the decrease?
Yeah, I mean, we're the same thing on the application side. So sometimes it's timing of when the applications are received. In the applications report, there is a decrease in applications. That, we'll have to just look at that and see. We do have the PTA programs growing, so we have those same questions, and so we just monitor the data and what's happening and see if that increase will come later as these new programs come online. And we are looking at those new programs early on in the accreditation process. So while we talk about it here, it may be early in that their, like I said, their accreditation process. So we may not see that actual impact until a little bit later down the road.
Yeah.
So
I love that question, though, something to look at. I mean, if it's happening every year, I mean, is everybody on vacation? I don't know.
I mean, it's surprising because pretty much programs are set. You can expect the same programs every year to graduate their cohort and take the exam at the same time. So to see a number like 26,000 decrease, it might be a couple programs change their end date or something. I don't know. Yeah.
it can also be endorsement applicants too. So it could be like a small percentage of new graduates, but also, depending on the number of endorsement applicants, if there's a decrease there, obviously that's more significant, that might impact the numbers more too.
Yeah,
So.
that makes sense. And then in that same paragraph at the end, there was $11,000 increase in unscheduled reimbursements. I mean, I don't pretend to know, all that could be, but it seems like what could be an example of an unscheduled reimbursement?
It's cite and fine, a citation
Oh.
comes in,
Okay.
or it be cost recovery.
Mm-hmm.
So a case, a person pays on their case,
Yeah.
amount owed.
Thank you. That's helpful.
This is a public ask. Oh, please, what is an endorsed applicant?
I apologize. Thank you for asking. That's an applicant who actually already holds a license in another state. And so they're applying to California using the qualification is the fact that they hold a license in another state. So they don't have to take the national exam to obtain licensure.
And, loosely, that's sort of called reciprocity. In some professions and licensing boards, it's called reciprocity. But it's more precise, the endorsement, because that's the manner in which this board operates.
So the the applicant is endorsing their current license to California.
Any further questions from the board?
Yeah, just follow up on that. I'm looking at the revenue line items. I do see the initial application and license had a decrease about, I guess, $70,000 from year to year.
That could be when people apply before they get licensure, they pay their initial license fee, and a lot of times what happens is they'll either go to another state, they'll drop out of the application process, and then you can see that there.
Okay. So it's not a concern that, we're not outreaching enough to get enough people to be licensed?
Not necessarily. I think with the initial license fee, they have to pay to become licensed.
Mm-hmm.
And when we see a decrease, for me, just looking at workload stats in the past, it's the applications are dropping off. They're not pursuing the license in California. Their application gets closed for some reason, and so that initial license fee is not coming in.
Got it. Thank you.
Sarah, could there be something else?
I'm sorry, you're talking about the initial application and license section in the revenue report
Yeah,
and the total?
right. It went from like 1.218 to 1.143, about 5%.
Yeah, I don't have a
Mhm.
direct reason for that happening. I don't have, no.
Okay. It's probably a timing difference.
Like I said, for us, it would be, we noticed that the application is coming in, so the fee's there, and the initial license fee is not coming in, so it tells me they dropped out or their application was closed.
Okay.
Again,
Thank
we
you.
can monitor this and see what the trend may be going forward. I don't know if this is just this year or what happens in the future, so we can keep an eye on it.
Sure, thank you.
Any more comments, questions, board members?
I just want to acknowledge the value of having someone who was in Alicia's seat. And it is big shoes to fill, and I'm glad that there's already someone, looking into the replacement. And it's just important for the board, I believe, to have our own person in that seat, so.
Absolutely.
Yeah.
Thank you.
Yeah.
Any public comments, questions?
Can I just add, I want to also thank Veterinary Medical Board for sharing Alicia with us today. So thank you to them, and also more congratulations to her.
Thank you.
Thank you for being here.
So I'm hearing no public comments. Alicia, congratulations. Wishing you the best as you continue to climb the ladder, and you will definitely be missed. Thank you.
I appreciate it.
Thank you.
We are going to continue and move on to item 18 on the agenda, licensing services update.
Good afternoon.
Valerie Kearney, Licensing Services Manager. Very technologically oriented here. Paul Rowe was appointed lead analyst for the Licensing Services Program effective July 31st, 2024. He is responsible for addressing the most complex issues related to the program, including military application review, licensing, and military licensees. He also serves as the program's outreach liaison and, under the direction of management, monitors program workflow and process effectiveness. Prior to his lead analyst appointment, he was the endorsement and military applications analyst. We are currently recruiting for a staff services analyst position that is now vacant with Paul's promotion. I've invited Paul up here with me today so that he can introduce himself to you in his new role with licensing services, and also so that he can update you with the military outreach events that he has represented the PTBC at. Go ahead, Paul.
Good afternoon, everyone. I'm Paul Rowe. Like Valerie said, I was promoted July 31st. It was very exciting to do the outreaches. I did 2 of them this summer. One of them was to San Diego. That was an awesome outreach, lots of people there. And then the second one I just came back from was at Fort Irwin down by Barstow, another exciting event. Not quite as many people, but very well, lots of information given. Also, I have been working with the license portability for military spouses, and that's been exciting too, keeping up with that. Can't think of anything else.
Explain the military, DCA's military.
So I have been doing the, like I said, I was doing the military spouse portability that is done through the DCA website. That has been, I've had probably about 15, I think, in the last year since it started, helping people, explaining to them, getting to either have their license, use their license out of state and register with the on the website, or to get a regular renewable license, explaining to military spouses what the difference is and what would better suit them for their particular situation. I can't think of anything else right now. I'm drawing a blank.
Are you all familiar with the portability?
Yeah.
Okay.
It's been very well. It's been working very well. It's a great program. Yeah. Any questions?
Yes, and congratulations. And
Thank you.
Welcome.
Thank you.
So we've had, and I don't know if this lands at your footstep or not, but we've had conversations about doing some outreach at high schools.
Yes.
And attended some career days because, as we know, especially in underserved communities,
Right.
The idea of a physical therapist, what is that?
Yes.
You know what I mean? So would that land on your desk, or is that?
Paul and I are sharing those responsibilities.
Okay.
April arranges the outreach opportunity. Right now, I think we've got several PTA programs booked up for a couple of months this year yet. PTAs typically will graduate in December as well. So we've got some of those. It's going to be a trade-off, whoever is available that day, kind of. But it is going to be Paul's primary responsibility as we move forward.
I've been mainly just doing military outreaches right now, but no, I'm very much eager and ready to go to any outreaches I need to go to. Yeah.
April, I saw you waving in the back, and I did take note of you when you mentioned that in your report. yesterday. And so I'm very excited and watching and hoping for the possibility for this presence to land in some high school. Because students need to know the possibility of having a career. It's a possibility.
It is.
Hi, sorry. Yes, we are going to work on focusing towards high schools. We actually do have one in Antioch that we're working with right now, and also with DCA to try to make happen. So fingers crossed, hopefully that will happen in October. And that'll be like a high school career fair, and it's like a medical-based high school. So we're trying to get the other medical boards on board with us to go do that. So yes, high schools are on our radar, and we are trying to get that going. So.
And like
Thank
April
you.
said, DCA as well, so we have the support of the department and trying to collaborate with them to further that reach.
Yeah, Tanya, I was going to say DCA did reach out that they want to, if I wanted to be involved, and yes. So, yeah.
I have a question.
Yeah.
I was just interested to know, we've got 8% foreign trained or foreign educated. I was wondering, do we know what countries that they came from, their primary, I don't know, I just was interested in the spread here in California.
Not right off the top of my head. I would say Puerto Rico is pretty big, as well as the
India.
Mexican. What?
India.
India, yeah. Mostly. Teresa had her first applicant that she had to get a translator for the other day, and they were from Korea. But that's really unusual. Usually it's the Latin American countries and India. And then we have some every once in a while that are English, basically from Britain or the mainland of Europe, who just happen to have gone to an out of non-accredited, non-CAPTE accredited program. So even though they are English speakers, they're still considered a foreign student.
Thank you.
Any further comments or questions from board members?
Valerie, do you have more to report, or is that?
I can go over the stats if you'd like.
Okay, I just wanted to publicly thank you, because I sit in a position from a program, and I know from time to time over the past years, you've come out to do some presentations, but there have also been some specific questions that I've had of you, and you're very, very helpful. Also, there have been times where I've referred students to contact you because you've asked them to do that when you came out to the presentations. And I do get feedback on how helpful you are, so I just want to publicly thank you for that.
Thank you very much for having us. I have to say, visiting U of P and doing our presentation is one of the highlights of the year.
Oh,
Really
thank you.
is.
Thank you.
Great group of students.
Thank you.
Also, too, I've got to say, I'm right in the middle of, I'm going to email all of the directors for all the PTA programs for California, introduce myself, and be their single point of contact as well, so that you don't have to have all the students, they don't have to call or whatever, they can just do it to me. So, yeah.
I just want to add one thing too. This covers licensing and enforcement, but I wanted to mention it here. DCA has really been working on the data and reporting, so like annual reports, sunset reports, to get some consistency of what we're reporting within each board, but also across boards for the department. And so that's been a huge effort, and it's been require a lot of involvement with the programs managers and staff. And so I really appreciate DCA taking this on, because it's when we report a data item, it could be 5 different things depending on the board that's reporting it. And so this was a huge undertaking, and I think a lot of progress has been made, and this should be seen in the next annual report that DCA releases. And so look for that. But it's along the lines of data policy data-driven policy and how important that is. And so we are part of that effort, and we're working on reports all the time. One other report that we are working with DCA on is phone calls. That's one area of workload that we have not been able to really figure out what the impact is to the organization. And so we have a new reporting system for tracking phone calls called CLABA. I believe I'm saying that right. And we are one of the alpha testers, so it's a very, very early on access to this program, and we're able to see the calls that come in, how long they take, were they, even if it was received, missed, did that person get a return call? And then, like I said, the workload impact so that we can use our resources most efficiently.
Yes.
So we're looking at that too. So really appreciate the department and all of staff's efforts towards this data collection and assessment that we're doing right now.
Yeah, more data collection is definitely useful.
I know, I'm excited to hear about the telephone, the tracking, the call tracking. That sounds very exciting.
Me too, to make sure that our stakeholders are connecting with us, and if not, why, what happened? So that's what we want to make sure that we are accessible as possible, if needed, in every direction, board meetings, outreach, phone calls, emails, we want to make sure that we are there.
Any further comments, questions, board members? Any public comment? I am hearing none. Thank you, Valerie. Welcome, Paul, and appreciate your reports. Thank you. I'm going to keep going. Moving on to item 19, Consumer Protection Services update.
Good afternoon, board members. I'm going to present the quarterly report or update for the Consumer Protection Services Program. First, I want to just say thank you to all of my staff. Each one of them, without exception, works incredibly diligently and carefully in all the many aspects of their job. They do so many things, and they do them so diligently and so well, and I really appreciate that. We do currently have one enforcement analyst vacancy due to our lead analyst, Christy Livermento, taking a position in the enforcement program of the Osteopathic Medical Board. This move is a great opportunity for Ms. Livermento, and we are just coping with the loss.
How long has she been with it? Oh,
she's been with the PTBC since 2008. She came just a few months short of when I came, so we've worked together for the last 15 years really closely. We were coworkers for 14 of those years, and she was my lead analyst when I became the manager. So really close relationship, really miss her, her skills, knowledge, experience, everything. Very sorely missed, but we're also very excited for her to take this opportunity at the Osteo Board with, of course, like Sarah mentioned before, it's with our former manager, Erica Calderon. So we're happy for her. However, while we are recruiting to fill the analyst position, the lead analyst duties that she undertook have been temporarily reassigned to me, and all the analysts are carrying a higher than normal caseload as they absorbed the cases that were assigned to her. So we are working quickly to fill that vacancy. It's in process, and we're moving forward as quickly as we can to fill that. I wanted to report that we recently held our first training for investigators from the Division of Investigation on August 14th. It was held online, and attendees included DFI investigators and supervisors, as well as PTBC enforcement staff. The training was presented by Deputy Attorney General John Gatchett, who is the PTBC's liaison with the AG's office, and he has done similar trainings for DFI in the past for other boards. In addition to, maybe not for other boards, maybe just general training, I'm not positive on that. In addition to this DFI training, the investigators were provided with sample documents specific to PTBC cases. For example, sample patient records, sample expert reports, so they can see what makes up a complete patient record, and those kind of things that are specific to what PTBC needs as far as our investigation. Let's see. So in addition to the investigator training, I just also wanted to add that for that investigator training, I want to say there was about 40 to 50 participants that weren't PTBC staff. So that included DFI investigators, supervising investigators, and other staff of DFI. So it was very well attended. In addition to the investigator training, Mr. Gatchett also presented an expert consultant training online last Monday. Expert consultants assist the enforcement unit staff with review of enforcement cases and evaluating whether or not the standard of practice is met by our licensees. Expert consultants are licensed physical therapists that we ask to review patient records, assist with DFI investigations and site visits, provide written reports, and work with the Attorney General's office as witnesses and subject matter experts in disciplinary proceedings. The goal of this expert consultant training is to train new experts, as well as to serve as a refresher course for current experts. Several prospective new experts attended the training last week, and now that the training is completed, I'm reaching out to each attendee to answer any additional questions they have and get them ready to take their first case. And many current experts also attended the training, as our goal is to have all current experts attend training once every few years, periodically at least. Any questions on that before I go over the statistics?
Do both of those happen annually?
I think that's what we're looking for. The DFI training, this was the first one, so we're looking at future trainings to happen annually. We're working with DFI on the timing of that. Expert consultant training, we started holding them annually in 2020, I think, was the first one we did. We did one in 2021 and again in 2022. Last year we did not do one, but brought it up again this year, and that's the hope, is to do them annually.
And they're both online?
Yes.
Are board members allowed to attend?
Yes.
Okay.
Any other questions on that? I want to just briefly point out some information from the statistics report that were included in the meeting materials. Last fiscal year, we received a total of 512 complaints. Performance Measure 3 shows the average case age in days for all cases that did not result in a referral to the Attorney General's office for formal discipline. The average case age was 166 days, or 6% higher in comparison to last fiscal year. These numbers are known to fluctuate greatly as they reflect the average of all cases and encompass the entire investigative process that involves the timelines, workloads, and response times of not only enforcement staff, but of all involved parties and agencies. Our target for this performance measure is 180 days, so we are currently meeting this target for this year. And that's the number of days from the time the complaint is received and opened until the time a decision is made and the case is closed. Performance Measure 4 captures the average case age in days for cases that were referred to the Attorney General's office for formal discipline. In quarter 4, 13 cases were finalized at the AG's office, which took an average of 535 days from receipt of complaint to final outcome. The total for the fiscal year is 41 cases finalized, taking an average of 764 days to complete. In summary, this fiscal year, we initiated 512 new cases, completed 501 desk investigations, issued 44 citations, referred 58 cases to the Attorney General's office, and closed 41 cases after referral to the AG's office. Our current workload is as follows. 410 cases currently open and being reviewed and or investigated. There are 20 cases initiated in 2021 or earlier. Some of these are either complicated investigations, but most are companions to a more recent case, and it's been determined that investigation of the more recent case needs to be completed before an outcome of the earlier case can be decided. And then several more of these are for licensees that were placed on probation and the case has been returned to the enforcement analyst for investigation and further action due to additional violations, either new acts or violations of probation. We have 49 open cases opened in 2022, 142 cases from 2023, and 199 cases initiated this year. I just share that information so that when you see the case age, you kind of understand that we're still going to kind of always have some of those cases that are aged several years, unfortunately, for various reasons. The 3-year performance measure report shows the complaint volume has slowly increased from year to year, for a total of 53 more complaints received last fiscal year compared to fiscal year 21-22. Other performance measures have fluctuated minimally, which is the expected which is expected due to the average being reported over hundreds of cases. And then finally, the disciplinary summary for all formal discipline issued in quarter 4. In this quarter 2, public letters of reprimand were issued. 2 licensees were placed on probation, and 2 licensees lost their privilege to practice, 1 by stipulated surrender and 1 by a default revocation order. Any questions?
Any questions, board members? Any public comment? I am hearing none. We have one more. Let's roll with it.
Yep.
Let's roll. Okay, so. Yeah. All right, we're going to push this forward. Item number 20, probation monitoring services update, and then we will break after you, Mr. Martin.
Good afternoon, board members. My name is Monty Martin. I am the probation compliance monitor for the board. Today I am reporting on fiscal year 2023-2024, the fourth quarter. And because it is the fourth quarter, I have also provided you the stats for not only this fiscal year, but the previous 2 fiscal years as well. During the fourth quarter of the 2023-2024 fiscal year, there was a high of 74 licensees on probation at any one time or another for various causes. Besides the 53 licensees on probation and actively working in the state of California, there were an additional 7 probationers on probation that are out of state or tolling, which means they're not receiving credit toward the completion of the probation. And there are also 14 in-state probationers tolling, so either underemployed or not employed in the state. There were 2 licensees placed on probation in the quarter, and 2 licensees successfully completed probation in the final quarter. Of the 53 licensees that are not tolling, 10 are enrolled in participating in the board's substance abuse rehabilitation program, which equals about 19% of the licensees that are in state and on probation. 1 licensee enrolled in that program in the final quarter, and 0 licensees completed the program in the quarter. There were 9 instances of non-compliance with probation in the quarter. For the entire 2023-2024 year, there were approximately 22 instances of non-compliance. 12 of those were for out-of-state licensees not showing up for scheduled interviews as they're required to do. And then a lot of the other 10 were related to 3 licensees whose licenses are currently being revoked for non-compliance. And then the final few were due to not showing up for scheduled interviews with myself or turning in quarterly reports late. Let's see, over the past 3 years, the number of licensees on probation has fluctuated from 72 in 21-22 up to 80 in 2022-23 and back down to 74 for this year. In fiscal year 2021-2022, 23 licensees were placed on probation as opposed to 16 in 2022-2023. It's probably due to the end of the COVID pandemic and getting back to normal, so there was a slight increase of people being placed on probation once we came out of that. However, there was also a significant decrease in the number of licensees that entered probation in 2023-2024. That went down from 16 to 9, and that's 9 is a number that's closer to the average that we would see per year. Typically, that 16 was high. The number of licensees that completed probation over the last 3 years dipped down from 9 in 2021-2022 to 6 in 22-23, and then back up to 9 this year. The number of participants in our substance abuse program has decreased slightly in the same period, going from 11 to 8 and then back up to 10 this year. And you guys have the stats for the fourth quarter, and then you have the stats for the this year that just ended, 2023, 2024, and then the previous 2 years as well. Are there any questions?
Any questions or comments? Board members?
It always seems that you have a good handle on the program, and we appreciate it. Thank you.
You're welcome.
Amen, ditto. Any public comment? Y'all smell pizza, huh?
Thank you.
Hearing none. Thank you, Monty. So we will break for lunch, and we have a special guest coming at 1:30, so we will resume at 1:30. Welcome back, everyone. Welcome back. So I know they told you guys that Bruno Mars was going to be here, but it's us, not Bruno, so welcome. So we are now resuming our meeting, and we are moving on to item number 21 on our agenda, student Q&A. Thank you guys for showing up. I really do feel like a rock star right now, so thank you all. I'm going to hand over the mic and the power to Scott Thompson. You guys, yes.
Should I approach?
Yes. And so, Scott, if you could just fill us in a little bit, and then we'll get this Q&A started.
Sure, of course. Well, thank you so much for taking time out of your schedule, or including in your schedule, the visit by the students from the Sacramento State Physical Therapy Department. These are our third-year students of the class of 25. They'll be graduating in July. This is their last semester on campus for their didactic part of the program. And in January, they'll start 2 consecutive 12-week clinical experiences. So I guess you could call them seniors. We don't really use that term, but they are, getting close to being done. They are in the middle of working on their capstone doctoral projects, where they're using evidence to support clinical decision-making from patients that they had actually seen over the summer. And so this is the final culminating experience for their doctoral project. So they're kind of in the midst of that. And we're taking them away from working on that to come and visit with the Physical Therapy Board of California. And we're really excited. Over the years, we've had board staff come and speak to the students, and then the students give presentations, and it's great to have the board staff there for feedback. But this is the first time, at least since I've been involved, that we've actually had a meeting here on campus so they can actually meet the board members. And they've been asked to come prepared with some questions. They don't know a whole heck of a lot about the board, so this is their chance to kind of explore what that is, and hopefully you'll be able to answer the questions that they provide. So that's all I have for an introduction, and again, just thank you so much for affording us this time. It's a really great experience, and for them to really learn about who the board is and what the board does, and why you're such an important part of the profession, and why they should be aware of that, and maybe even learning about how to get involved as their careers progress. So.
Thank you so much. So, yeah,
so I'm going to so I don't think they know they're going to be called up to. I thought some of them think they can hide in the background, but that's not the case, is it?
So, Scott, this is what we'll do.
All right.
So we'll introduce ourselves
Yeah.
to everyone, and then we'll go ahead and move the program along. So
Sounds good.
How about we start at this end? Yes, you, Sam.
Right, so my name is Sam Q.
My name is Sam Q. I'm a public board member. I was placed on the board December of 2023, I think. So I'm still fairly new, so I'm learning a lot. I'm actually an accountant and a CPA by profession, but my business is sort of healthcare related. I have a lot of clients are healthcare, mental health, physical health, federally qualified health centers, and work a lot with not a lot of physical therapists, but OTs and some of the doctors and also physicians and nurse practitioners, a lot of the healthcare professionals. So when the opportunity presented, I was interested to get on this board, and I made the right choice, and I love this board, and I love how this industry is positioning itself, and I'm glad to have the opportunity to contribute, and whatever questions I can answer from a perspective of a professional, I can give advice, and I own my own business, so that's something that I think PTs eventually, a lot of people would have your own clinics, and some of the administrative steps and ethics and things like that, it's translatable between professions. So I want to welcome you guys, and thank you for your time and participation.
Hello, I'm Karen Brandon. I'm also a board member for my first year. I was appointed by the governor, and I'm a professional member. I have my doctorate of science in physical therapy, and I am a board certified specialist in women's health. I practice in a large group, a medical and healthcare practice in Southern California. And I also teach at 2 or 3 facilities as an adjunct professor. What else do I need to share? This has been a really exciting experience. Being a part of a board is another way that you can contribute to healthcare, because your professionalism, your understanding of what we do helps to inform the public of what to expect in terms of when they see a physical therapist. It also protects the public, specifically keeping our standards very high for what we do. And it also serves to create standards inside of our profession that can last for a very long time. A lot of the decisions that have happened before I came on the board, and that I'm going to be contributing as I'm continuing on the board, are going to make a difference in practice for years to come. So it's an opportunity, I think, that I'm really excited about, and learning a lot from the board members in terms of the history and also what's important in physical therapy right now.
Good afternoon. I'm Alicia Rabina Amen, and I've been a physical therapist for over 25 years. I've been on the board for almost 10 years now, and I didn't seek to become a board member, but was nudged, and I was like, really? And I was a licensee, but I didn't really know what the board did. And a lot of licensees still don't know what the board does. And when Jason Kaiser, the executive officer, comes and does presentations to our students, I'm actually at University of the Pacific. I'm the director of clinical education, so I work pretty closely with Dr. Brian Salgado Coleman. And Jason Kaiser will say, think of it like your driver's license in AAA. You've got your driver's license regulated by the state, and you've got your professional association. You've got the Physical Therapy Board, and you've got the CPTA, right, or the APTA. So, reconciling the difference when I first came in was a learning curve, but this board reminds each other and ourselves very often that we exist to protect the public. And so, was appointed in 2014 by Governor Brown and then reappointed again in 2016 and then reappointed by Governor Newsom in 2020. And I will also add that having 4 licensed physical therapists on the board as well as 3 public members is a beautiful balance, because then you don't just have licensed members driving decisions. You've got perspectives of these 3 public members who come from different walks of life and have different life experiences and are able to call things to our attention as licensees that we might be missing or not seeing. So just want to acknowledge what a benefit it's been to have 3 public members on the board.
Hello, I am Tanya McMillan, and I am the president of this wonderful board. I am also a public member. I'm a retired family child care provider. I did that for 30 years, and now I am an early care and education advocate with a statewide organization. I was appointed the first round, and like Alicia, I knew nothing about boards, period, by back then the Senate Pro Tem Kevin De Leon. And then I was reappointed by the Senate Rules Committee, and so I am so honored and so proud to be a part of this board. I am so honored that I have been given the responsibility to be the eyes of the public and to be the voice for the public, sharing our perspective and being a part of the decisions that are made on this board on behalf of the public of the state of California. And so that is, that's who I am. And if I can answer any questions for you from the public viewpoint, then I will be happy to do so. I'm so happy to see you guys.
Well, I'm the board's lawyer, so you don't want to clap for me. I'm Michael Knotes. I'm the board's legal counsel. I've been legal counsel for a little over 5 years. I help them in closed session talk about disciplinary cases. I sit with the board during our public meetings and a lot behind the scenes too. So nice to meet you all. Nice to have you.
Hi, I'm Sarah Conley. I'm the Assistant Executive Officer for the board, and I've been staff for the board for over 20 years. I started as a student and worked in all the different programs. I'm very proud to be staff. This is an amazing organization, and they truly understand the mandate of consumer protection, and so that's something for you all to be aware of, is this board is always focused on consumer protection and everything that they do, from license requirements to enforcing the laws and regulations. Even in consumer protection, if there's a complaint and action is taken against a license, it's never punitive. It's always measures put in place to make sure the consumer is kept safe. So again, just very happy to be part of this effort, consumer protection and board, and I'm glad to see you all here. So thank you.
Hi, I'm Brooke Arneson. I'm the Legislation and Regulation Manager for the board. I started in about, I think, 2013, so a little over 10 years, and we're just really excited to see you guys here. I can't wait to hear some of your questions.
Okay, back to you, Scott.
Okay. I guess we'll just turn it over to students here, and we'll have them approach the microphone, because everyone's going to need to hear what they have to say. So I guess we can do volunteers, or do we
Scott,
just go in order? Yeah.
Before you go any further,
yeah.
I might add
Yeah.
that this is live webcast, so your classmates will have an opportunity to see you guys today. So yes.
Yeah. Thank you for reminding. Yeah, this is a public forum. So, Anthony, would you like to start?
Sure.
So maybe first, obviously, introduce who you are, and then share any questions you might have.
Press the little button until it turns green.
It's green, yeah.
Okay.
Hi, my name's Anthony. I'm a third-year doctoral physical therapy student. I had the privilege of participating in a school board in my previous career as a high school teacher, and so I'm curious, what incentives are there for us as PTs to one day participate in a board like this?
I think, as Alicia mentioned, a lot of what happens with the board, even as a licensee, you may not be privy to the things that are coming up in physical therapy, things that are coming up in legislation that affects physical therapy. And so I have been excited to have someone automatically create, summaries of some of the legislation that I would never probably even know about unless I was up here at, the Capitol finding out about the details. The other thing is, I really do like the idea of being able to impact the changes. Sometimes there's a legislation and we write a letter of support or we write a letter of opposition based on how we feel it's going to affect our duty to protect consumers and also the process of licensing all of you and us. So I think the opportunity to learn a much broader understanding of how PT fits into all of healthcare and all of that service that goes out to California. And also, Sam and I are part of I'm just trying to think about, you're the candidate, no, you're the delegate, and I'm the assistant delegate, right?
Yeah, you're the alternate.
Alternate delegate for the FSBPT, which is the Federation of State Boards. Then we get to see how it's practiced in other states, and then share a little bit about how California does it, and we find out innovative ways on how we could potentially do it better, which is pretty exciting.
Mm-hmm.
Yeah, don't get an opportunity to do that unless you're in something like this.
Yeah. Thank you.
Thank you.
I have one more question. So I heard a number of you speak about protecting the consumer, and it's within regards of that. I've seen a number of what I will call physical therapy adjacent clinics around the state that aren't necessarily advertising physical therapy, but are advertising things to the layperson that sound like physical therapy. And so I'm curious to hear if that's a discussion point among you guys and how you guys seek to protect the consumer when they are looking for rehabilitation and are not sure where to go, and how they can distinguish between a cash pay clinic that may just offer massage versus a chiropractic clinic versus a physical therapy clinic, and where you guys help draw those lines and make it easier for the consumer to know what they're purchasing.
That is something the board wants to do more of, is try to connect with consumers. Obviously, the easiest way for us to connect with consumers is through all of you, the licensees, because you are working with them. But we do try to put information out on the website at these meetings and try to provide information to the consumers to identify those differences. Some other professions can do modalities that are of the same, and so you had trying to identify that can be difficult for them. So we try to just provide that information and have consumers be informed. That is a difficult area, but we do rely too on the enforcement program. If there are concerns, complaints can be filed, and we can look into that. If there might be information that's misleading, that it's not physical therapy, they're not licensed individuals, or PTs and PTAs there, but they are advertising they provide those services. We can go in and look at that and say, okay, what's going on here? Is there a violation of the Practice Act? What can we do about that? If there is, then we would address it and stop that from happening. And so, but definitely that's something we continue to look at. How do we inform consumers of that? Because part of it is on the consumer to have that awareness of what they are, what they're choosing, where they're choosing to get care. I don't know if the board wants to add any.
I just love that you said PT adjacent. That's a new term, love it.
All right, well, thank you for taking my questions. I appreciate it.
Delvin? Oh, you need to turn it to.
Hello.
Oh.
So I have another consumer-based question. Just push it in once and then it should light up green. Yeah. I have another consumer-based question. So what is typically like the investigation process for, so if a physical therapist partakes in like an unsafe activity, what's the investigation process? How long does it normally take? And then what's like the array of disciplinary action? Like, is there suspension of license, like permanent expulsion of license? So I was just curious about that.
That's a great question. I'm actually going to have the enforcement manager come up, and she will be able to provide you a lot of information on to that. Oh, there you go.
I can stand, that's okay. Would you mind just repeating your question?
So first of all, what's the investigation process of whether or not a PT partakes in an unsafe practice? And then what's the hierarchy of disciplinary action?
Okay, and just to introduce myself, I'm Carol Phelps. I'm the manager of the enforcement unit at the Physical Therapy Board. The investigation process varies from case to case. It depends a lot on what the complaint entails, what action or omission is alleged. We do investigations which include obtaining patient records, interviewing the parties, site visits to the facilities. Those are the main three things when we get the patient records. We also have expert consultants that work for us that are physical therapists. They'll review the patient records for us, observe at the site visit, and they're the ones that can tell us what the standard of care is and whether it's been met in this case or not. And then if it's not been met, then our range of actions that we can take, obviously if there's no violation or if the violation is extremely minor, we close the case with no action. We can educate the licensee in a letter explaining what the relevant code section is or what the relevant law is that might have been stepped over. We can cite the licensee, which is a public action. It stays on their record for 5 years and usually comes with a fine. And then there's disciplinary action for the more egregious violations, which disciplinary action is permanent, stays on your record. It is part of your DCA license lookup, and it can range from just a letter of reprimand, which just basically states what the violation is, or you could be probation, where you have a probationary period where you have to meet, you have terms that you just have to comply with, or there's obviously surrender or revocation of license for the most serious violations. That's the range.
Thanks.
That's great, thank you.
All right, one question's fine, Jack.
All right, I have no other questions.
I wanted you to come prepared with more than one, just.
There's someone back there who was raising her hand.
Oh, all right. You want to just come up? All right, okay, that's fine.
I wrote them down so I wouldn't forget. Hi, I'm Emily. I'm a third-year student. Ooh, press the button. That one. There we go. I'm Emily. I'm a third-year student. I'm actually the class president of all these wonderful people back here. Could you just share some of the things that maybe you have worked to pass that you're proud of and how they impacted physical therapists?
I'll start. So from the very first hearing that I was a part of, my eyes were open to so much that you guys have to do as practitioners, the regulations that you have to follow and why they're so important. A lot of the stressors that PTs and PT assistants have to deal with and the way that they deal with them that lands them in front of this board. I was very surprised to hear about there's so many DUIs, but it also opened my eyes to the roles that you guys play and what you carry, the weight that you carry, especially for what you have to do with myself, the public. And so this has just been such a learning experience for me, but it's also been very eye-opening and very rewarding. And so that's one thing I'd like to share about my experience being on this board.
Let me just very briefly add, there's lots of good reasons not to drink and drive, but when you become a licensed professional, you can add to that list. You're jeopardizing your career. You're jeopardizing your license. So take an Uber, folks.
I think that's probably the most, my biggest piece of advice as a board member, even after 10 years. It was the first eye-opening item to me when I first came on the board, and we just welcomed a new cohort in at UOP. And in my last class, I remember sharing with them, you know, you want to go out and have fun, go out and have fun. You know, have a couple beers, have a couple glasses of wine, what have you. But take Uber. There's like no excuse nowadays. You know, you've got Uber. But don't let a night of fun ruin all the hard work and sacrifice and money that you put into becoming a physical therapist. And on that line, I will say, if for whatever reason the board calls and asks for information about something, or you disclose, I had this contact with the law, because you will have to disclose that within 30 days, just cooperate with the board. It makes things so much easier. I mean, it's a scary thing, but if you're cooperative, it can really work in your favor in many ways. So that's one piece of advice I'll have. But specific to your question, I really thought about, okay, what's one example I can give you? And the example I'm thinking of has to do with foreign educated physical therapists. They have a much different licensing process than all of you will have as CAPTE graduates, CAPTE educated physical therapists. And when they do a clinical supervised practice in California, they're under the supervision of a licensed PT, just like you are for your clinical experiences. But we have relied on an old version of the CPI on paper for an assessment of that foreign educated graduate. It's done the job, but we've known for a long time we can have an alternative that's something better. And the FSBPT did produce a tool specifically for foreign educated PTs. And that was one rule that we changed here with the board. That's one regulation that we changed, that we adopted to include that tool. So that's just one idea of an example of some work that we do. And I'm proud of that. Yeah.
Since I'm new to the board, I can't speak to how long the process has been with different things, but I'm super excited that I was part of transitioning the California jurisprudence exam for you guys now to the CalJam. And, you know, that's, you know, aligning with the kind of the innovation and how other state boards are doing that. And we really hope that that makes it a different structure, gives us better passing scores, but also like the information is there for you to kind of look and correct yourself and give yourself some resources for why and where that information came from. And one thing I'll say that I definitely didn't think about until I was on the board, there are many, many laws out there in our country in general that you may not agree with. But at this moment, they are in process and they are how we are supposed to conduct ourselves, right? And so definitely become a part of an entity if you want to change those things. But in the meantime, these are the laws that we have and these are what we uphold. So if you have a question, certainly you can ask your best friend from PT school or you can ask your boss, but if in doubt, you better call the board and find out about that specific part of the Practice Act, because every week we get information about regulations and enforcement, and a lot of times people just, they didn't know. They didn't know to ask about something. They thought they understood it, and it comes out as a problem on the other side for a consumer, and that's what we're addressing. So when in doubt, just ask. But hopefully you all pass your CalJam awesomely next year, and we're looking forward to having you guys as licensees.
I want to add that I said, I was part of the process of this new rule coming into play. I had a say in it, but you have a say in it too. You have a say in every single thing that we discuss in these public meetings. And we don't get a lot of public participation. As a matter of fact, we're actually thrilled that you guys are here. We're very, very happy to see you out there and answer your questions. We love having your questions. But even when you're licensed, if you can make it to a meeting, and sometimes there'll be a virtual opportunity to make it, but when there's a call for public comment, jump in. This is our discussion, right? It's not our discussion. And so you, even if you're not a board member, you still have a say. You still have a voice, and that's what's going to make the policy better.
Can I add to that too? And that's the time to speak up, because a lot of times what happens is if we haven't had a rulemaking or creating a regulation, which a regulation defines the law or the statute, that process is it's very public, and there's actually a specified time frame that we have to allow for public comment. And if you provide that to the board has to take it under consideration. It doesn't have to take those and incorporate them, but it has to at least consider the comments. What happens is we will implement a new regulation, and then licensees will contact us and say, well, this isn't going to work. I don't agree with this. But at that point, if it's already been adopted, that there is nothing that, it can be changed, but you lost your opportunity to give your perspective that had already happened. So sign up for the board's mailing list and attend the meetings, and just be aware of what's going on so that you can provide that feedback to the board if you'd like. Yeah, that's it.
Thank you. I did have one more question, just because I was a little bit surprised that there were public members on the board and they weren't just all physical therapists. Do you have any examples of kind of maybe opinions that the public members have brought in that have, as therapists, maybe even you were kind of surprised by or didn't think about?
So I was surprised too. But I did learn that every board in this state has to have a public member on it. You can't just have all practitioners on a board. You've got to have somebody who's going to represent the other side. And so that's why I said it's such an honor for me to even hold this seat. It's heavyweight. But we have heard at different hearings, we've heard PTs, PTAs who have found themselves in the unfortunate position to have to come and plead their case to us. We have an opportunity to have conversations with them, and I am so grateful that my public eye does not give the same response or ask the same question as the doctor's eye. And I'm pretty sure they are too. Because at the end of the day, you want somebody that may possibly be your patient one day to trust you. To trust you, even if I have seen you sitting across that table from me, and it could happen. And so, I don't know if I answered your question.
Yeah, no, that was great. Yeah, thank you.
This whole role as a public member, like I said, it carries a ton of weight. When I think about Monty Martin, he's the probation monitor. I did not know that there was a probation monitor, somebody who is keeping in contact with folks and tracking it before they can come back out and have me as a patient. And so just knowing that these things are put in place to protect me, and that I am the person that's going to go out there on the streets and say, yeah, go see that physical therapist. Like, they have rules they have to follow. They have, and my voice is valid because I hold this seat. So that part.
Yeah. I like that, thank you.
Yeah, being a consumer, being a public member, I think we sort of approach things in a more consumer point of view. There could be, a relative or a friend or somebody around you may have received PT services, and before, so I think part of the missions of the board, the mission of the board is protect the consumers, but through that process, I think some of the vehicles is to inform both the consumers and the professionals what the rules of the game is. And the better you inform them, the better I think that collaboration and the protections can be offered to the consumers. And I think that's probably the perspective that we can contribute, and in the process that we're learning also. And by bringing that sort of a different perspective is what we contribute.
Let me just add one more thing. By the way, there are 3 members who are missing. We have one more public member. She couldn't make it today. Dr. Armstrong, she couldn't make it today. And the executive officer, Jason Kaiser, could not make it today. So,
Oh, I was just going to say, what Madam President mentioned is very, very true. Sometimes as professional members, when we are looking at an enforcement case, there's everyone has some level of perspective on it. Sometimes a therapist might say they should have known how to do that. Meanwhile, the consumer is, or a public member is like, I see the problem. I see some of the challenges that might have brought forth, right? Another interesting thing I think that has occurred, and it's not specific, but sometimes we live in a bubble as physical therapists, and we presume like everyone understands what we're saying. And there have been many, many times when we've had to talk amongst ourselves to help everyone understand what something means, and then determine if what we're most concerned about, it rises to the level of the value of the consumer, right? So I don't know, an example, I'm just thinking about maybe advertising physical therapy and et cetera, and maybe a public member might say, well, that's not something that I would be even worried about, right? Whereas we might be worried about something. I'm not talking about what he just mentioned in the Practice Act, I'm just saying in general. So there, I think it is amazing to have the variety and the diversity of perspectives, and including young and old, including academic, research, practice owner, business owner, yeah.
Thank you all, and thank you for having us today.
Any volunteers before I start calling up people? Okay. I guess no shortage of volunteers.
Hi, I'm Melissa. I have a question for Karen. I guess anyone else who's also practicing as well as on the board. I was just wondering kind of what your work balance is, maybe, and if you feel as though it's easy to transition from, board mode to I'm in the clinic mode, or you feel like maybe they're nice kind of seamlessly rolled together because, like you just said, you have a little insight.
So I think this is not my first board that I'm on, right? So I've been on a couple other professional boards. So just having that recognition that, okay, when I'm doing my regular JOB, that is like showing up in the clinic, having scheduled appointments, et cetera. And then separately, maybe in the evenings or the weekends, I'm taking a look at what my messages say. And this board is amazing because they are completely understanding of the fact that we do have this other part of our lives. But also I think that, I think it's a very good thing to, if you're adding on to what you do, that you're carving out some specific time to keep up, to take time to read, so you're not rushed for the next board meeting, so that you have something to engage in and you can actually be a participant, right? And it just ends up being that there's something else that you're cutting out because this is a value to you, right? And, it's not forever, although it could be for a very long time. But my point is that, you want to you're going to have a learning curve at the beginning of any kind of responsibility outside of your regular vocation. And as soon as that learning curve is over, you want to be able to engage and participate and make a difference because you were there. Use it while you have that opportunity. And one way to learn more about the board is we are online for all of these meetings. So if you want to scroll back, you can go on YouTube and see many, many meetings in the past to see kind of what we talked about and how people maybe even show up for their disciplinary action or their requests for different things about their license. Mm-hmm.
Can I add to? I always have something to say. When you talked about the work balance, I'd like to share my experience with it as a public member because, this is not my day job, but I know the first time that I received a case, all the court documents, and having to read those documents and learn regulations, and it took a lot of time. And so I actually have to carve out a certain amount of time because at the end of the day, this case is somebody's livelihood. And for me to take it for granted or breeze through it or half-ass look at it is unfair to them, but it is a horrible place for me to be as a board member. And so there not only is everybody carving out time in their normal lives to make sure that we uphold the oaths that we took to hold these seats, we have to make space to make sure that we're staying fair and that we are giving our unpolluted clearest thought and mindset to the roles that we are holding on this board.
Great, thank you so much.
All right.
Hi, my name is Alex Walker. I wanted to ask if anyone could comment on the relationship that the board has with the CPTA or APTA, what that looks like, if you guys spend a lot of time in communication with them or just a little, how that works.
So the board does communicate with the association. It's important to have I think a respectful, positive relationship, which I think this board does have with the association. And so our goal is to make sure that we have transparency and we share with them what we can as far as what the board is working on, and we share information about legislation and rulemaking. And I believe our meetings are quarterly. So we meet with them quarterly before a board meeting to get the association's feedback on things and what's going on with them. And so we have an open line of communication, but we also have to respect the boundary of the association representing the licensees and we are representing the consumers. So we're collaborative, positive, but we do represent two different views. And so it's actually, we expect to disagree sometimes. If we disagree, we're both doing our jobs. So I hope that answers your question.
All right, thank you.
Oh, goodness. Wow. Mary, you're getting beaten down.
Hi there. Is this on?
Press the
Push
button.
it once, and you can just leave it on.
There we go.
Yeah.
Yeah.
Hi, I'm Ryan Maves. I wanted to know if you guys might be working on something or have considered trying to build some sort of reciprocity between licenses with different states.
Well, our current process is we do have an endorsement process, so are you talking about the compact, or?
Not specifically about
Okay.
the compact, but I was considering it a bit.
Okay, so the board currently has a process in place for endorsement for licensees out of state to come to California, and what that licensees still have to apply here in California. They provide their the information of their current license somewhere else, as well as having to take the law exam and fingerprinting. So there's all the application requirements they have to adhere to. The main difference is that they don't have to take the national exam because they've already taken it. As far as there is the compact, I don't know if all of you have heard about that, but there is, it's through the Federation of State Boards of Physical Therapy, and you can apply to be able to use your license in any other state that's part of that compact. And there's a map that's provided through FSBPT it's a good portion of the country. I can't remember exactly how many states, but it's a lot of them. And so you are part of this compact, and you can practice in any of the other compact states. And I think there's some fees and some requirements but the requirements are fewer than if you were to apply for a license in those states. The California is not part of the compact, and at this point there are no plans for California to join the compact because there are some regulatory concerns as far as if there's any violation of the Practice Act, who would have authority and what can be done to protect the consumers in California. So there is a process for licensees to come to California that if they already have a license that is, would differ from a new graduate. However, the California is not part of the compact that is available to some out-of-state licensees.
I think that's a great question, and probably a common question. And if you look through the meeting materials, and specifically the application and licensing part of it, it does give some timelines of how long it takes to process licenses. And it actually is taking less time to process a license through endorsement than for a CAPD graduate. So I believe I can look back on my time here and I can really see that staff has streamlined that process. And so with a compact, I think it might be easier in some respect, and maybe we're looking at things differently because it's not that compact privilege, but the state of California is doing a really good job at processing those. Yeah. Thank you.
Of course. I do have a second question. Is there something you guys are working on right now that you think we should be aware of as students about to get our license?
You've stumped the board.
No is also an answer.
Pay your renewal on time, get your CEUs done, get a file and file them away as soon as you take the class, because then it's easy if you get audited. So, I mean, these aren't things that we're working on right now, but these are just like real basic important things as a new licensee to know. Just stay on top of what you need to stay on top of and stay informed. Subscribe to the board's newsletter and any links, so that you can get the automatic pushes that the board puts out for meetings. Or, for instance, I just got something last month regarding when I renew online, I'm now going to be paying that fee for my credit card. The board used to have to incur that, and now they're passing it on to licensees. So I just got to push through as a licensee that says, okay, now this is going to be the process moving forward. So you'll get these if you subscribe, and that's how you'll know what the board's working on.
Gotcha.
Mm-hmm.
Thank you.
Here I go again. But also the fact that, and this kind of goes with your question, these seats are not forever on this board. So the board that you have right now, in a couple of years will not be the same board. Like, we term out of these seats. And so you would also want to keep track of who's representing you on this board as you go through your career. This was our former president, and I'm stepping in her footprints, and there's still a whole bunch of space in the footprint, so like tighten right here, yes.
So I think to be a board member appointed as a licensee, you have to have 5 years' experience. And so I would just encourage all of you to stay open to that. I mean, there is nothing that I felt was special about me to hold this seat. Just because you are you and you have your own experiences, you have a voice. You could be doing what I'm doing right now. I always say, I'm just me, I'm just Alicia, I'm nobody special. You know, I remember when I came in, I said, I don't own a private practice, I don't do this, I don't do that, I'm just your straight middle of the road PT. And they're like, you're exactly what we want, because we don't want anybody in here with an agenda to try and change things or steamroll their ideas through. We want someone with an open mind. So I just want to encourage all of you not to be afraid of this opportunity. And after 5 years, you could be sitting where I'm sitting.
One more thing, there's other opportunities to engage. We have expert investigators, expert witness type that come and participate in some investigations, help us understand how things were practiced in specific cases. And also for those of you interested in specialization, pediatrics, home health, those are also very highly utilized, because we need people to understand if the expectation of best practices and all of the laws and regs were followed in certain specific cases. So don't forget, those are also great opportunities to start to get engaged with our programs.
All right, thank you guys.
I'd like to reiterate what you have said, and I try to stress this with the students as well. Sorry, Mary, I know you're wanting to come up. It's just not going to happen. No. You know, I've told the students that, you know, they are the future of the profession, and you know, I, as a younger PT, did not get involved in the way that I am now. And you know, we often think, oh, we might want things to be different. Well, you're the conduits for change here. And so maybe not in your first couple of years as you're getting your feet wet, but certainly, you know, whether it's getting involved in the board, and that might take 5 years, but there's just so many other opportunities, even outside of the board. And I think it's really important that you are the future change makers. Actually, not even future, it's coming up really soon. You are the change makers for the profession, and whatever role you decide, you know, take the bull by the horns. It's a great opportunity, and people will welcome you with open arms to become involved. That was the one thing that surprised me, that I thought there'd be resistance. But really, if the door is cracked open, all you have to do is give it a nudge, and trust me, people will open it up for you. And it's really remarkable. And then, yeah, you get to shape the future of the profession and for yourself. So do keep that in mind. I know it sounds a bit cliche, but it's true. All right, we're out of time. No, I'm thinking about Sorry, Mary.
Hi, my name's Mary. So my first question is, how do you become a board member? I know some of you said that an opportunity came up, or that you were appointed by the governor. So if some of you can kind of speak to what were the steps that made that happen.
Okay, so I had a wonderful laws and regs instructor. And when I started teaching, he became a colleague of mine, and he was very involved in government, but also specifically paid attention to every little thing on the board. And when he started asking me, have you been paying attention to the board, programs, and, watching every quarter? And I started following. I got really excited about some of the items on there, and he was like, well, you don't have a voice unless you go and be a public member, or you can apply. And looking at the terms kind of passing through, I noticed that there were going to be some opportunities. And there are many different ways. I'm not sure if professional members are all appointed by the governor, or if some professional, so the professional members are appointed by the governor. But you can put your application in at any time, and then the appointments clerk and the deputy appointments clerk will keep those, review those, and then call those specific ones that have met all the criteria for interview. And so that process occurred for me actually right before COVID. And then I had to wait because there was no appointments being filled at the time. And then I got a call for another interview with those administrators at the Department of Consumer Affairs. And then I found out that I was able to join the board, and I was appointed. So yeah, I think that process for that piece is just turning in your application and staying in contact and learning about, as much as you can about what the board does and watching. I actually saw her online way before I ever met her. So, and yeah, I'm fangirling a little bit, but it was really impressive to see how she was able to make change happen and like have her voice heard, and that like really inspired me. So, yeah. Thank you.
My second question is it a requirement to kind of live near the Capitol? I live pretty far in a rural area, and so I'm just wondering how that would impact kind of involvement. I know there are other ways to get involved that we had already discussed.
No. No, I live in Compton. I live in Southern California, and so we're all from different parts of the state, so no.
Wonderful. Thank you very much.
So part of that, just full disclosure, there's a budget to get board members where we need to go. And generally speaking, we're trying to represent the whole state, right? So we go north and south as many meetings as we're allowed to have, which is generally quarterly. So, yeah.
The appointment secretary is going to look at the current composition of the board and try and diversify that if they can. So, I'm in home health. We've got pelvic health. We've got pediatrics. If there was someone in a rural area, that could be a value to the board, a big value to the board, especially since there's a lot of talk about getting health care in rural areas. So, something to think about.
I think in healthcare in general, penetration in different markets is, especially rural areas, it's a big push for it nationally. It's problematic, right? Because it's hard for ambulance to get to places. It's so emergency medicine is very, very difficult in rural areas. And also practitioners, because there's no setup in the rural areas, not enough capital to go in there, professionals don't go there. So there's a huge lack of, in addition to the regular lack of providers, the rural areas are facing even more difficult situation. So, I'm every time I encounter a professional, I always wanted to ask them, and that's why there are incentives actually created for rural areas and disadvantaged areas, that you be able to get your student loans discharged if you go work for certain organizations that qualifies for it. And I highly encourage that. A lot of times those are the areas that are systemically short of any kind of healthcare professionals.
Did you say your name's Mary?
Yes.
Mary, so imagine if you were on this board and we were all having a discussion, and many of us were talking from our perspective, and we thought something was supposed to be a certain way. You can say, hold on a second, I actually happen to practice in a rural setting, and it's not like that at all. Value.
Yeah.
Yeah.
Thank you very much.
All right, thanks.
Hi there, my name's Jackson. You'd mentioned that there's a certain amount of federal
communication or representation that this board has. I was wondering if you guys feel there is something that the practice of physical therapy in California excels at when compared to other states? And alternatively, is there an area that you feel like California physical therapists lag behind when it comes to other states? Or is there something that physical therapists in other states can do that you wish or are working towards getting therapists in California to be able to do?
So I think each of us have had the opportunity to participate in a FSBPT meeting of some sort, whether it's virtual or in person. And the beauty of participating in that meeting where all states are represented or most states are represented is that you get to see these exact differences. You're like, oh my goodness, we are doing that right. We are leading the way right here. Oh my goodness, I think we can improve this over here. So that is one way for us to kind of compare just by participating in FSBPT. I think we've improved many processes just by our interactions with them. And there are some things that the FSBPT and actually states in particular kind of move toward. And sometimes when one state moves or a few states moves, other states tend to move, and California doesn't move. And I think that's a very valuable thing because we kind of sit back and watch and we see. And we benefit, most of the time we benefit from not moving because there were some things, there's a benefit to not going first all the time. There are some things that occur that help open our eyes like, ooh, glad we didn't do that, so that's also a benefit from being with FSBPT.
I think that our executive officer shared at our last public meeting that people do look to California, and there are some places that we have strengths. Our Practice Act actually is one of those that across the states has been identified as having really good bones, being able to uphold. And there are things in it that are still not perfect. And it's pretty cool that that is one place that we interface with the CPTA going forward in making recommendations for amendments to it. But, if you go back in our public meetings, you'll see we have had conversations about veterinary medicine, veterinary PT. We have had conversations about dry needling. There's a lot that goes into that impacts California a little differently because of the other interfaces with different medical professions that may not exist in other states. So those, like I said, those discussions, when we have it on the agenda, that's what you want to be looking for because A, you can public comment, and B, you can kind of hear more about where we left off with that conversation. I hope that helps you.
Yeah, I think I just want to add by listening to you is that I'm not saying the other states are wrong for doing what they feel is important for their state because the other thing that I've realized is all states are different, and we're a big state. Yes, and so what benefits another state just might not be in our interest. Yeah.
I'll just add there are some consumer protection things to consider, and one of the things that stands out to me nationally versus California is California does background checks, fingerprint-based background checks, and I thought all states did that. Not every state does that, and so those are the types of things that California will not move from. That is, we're not going to change that because the safety comes first. And so we're trying, and that's where on a national level, we want to make sure to see if we can get states to rise to that expectation to ensure, like, especially with all of the discussion of license portability, that standards across the whole nation. But it's also true for even like education requirements, like foreign educated students. The education that's accepted for licensure in other states, is that equivalent to what we would accept here? And those are the kinds of things that we have to look at.
you very much.
Thank you. Anyone else? Start calling up people. Asha, do you want to join us? Or
Hi, my name is Cameron. It was mentioned earlier that there are some disagreements between the California Board and the APTA. I was just curious what some examples of disagreements between those two organizations are.
I don't know that we have necessarily disagreements right now. Like, there's nothing specific that stands out, but there can be just a different view and what's being represented. So, for example, when we talk about the Practice Act and potential changes to it, the association may want to change redefine the scope of practice. Well, that's something that the association would have to carry because that's not a consumer protection concern for the board. I mean, if it is, the board will speak to it, but if it's an expansion of scope, that's something the association will look at. So it's not necessarily a disagreement, but it's something that we would not necessarily, or the board would not necessarily get involved unless there was a concern.
Okay.
I don't know if you have any.
And when Ms. Arneson presents the legislation report to all of us, sometimes the CPTA will come forward and say, this is our sponsored bill, or we agree with this bill, and we would appreciate the board's support. And then we get to make a decision how we might feel about that, or if we want to write a letter of support. And sometimes we do, and sometimes we don't. Nothing personal, but we are looking at it with our consumer protection hat on as far as matter of importance.
Okay.
Yeah.
Gotcha. Thank you.
Thank you. Any volunteers? No? There's another one. All right.
I don't know. Recently, we were informed that the syllabus has changed to incorporate information about artificial intelligence and AI. Is that something that is being discussed at the level of the board, or is that something that you're concerned about at all?
Yes, that's actually in the forefront of the issue in the nation. I just attended the Leadership Issues Forum in Washington, D.C., and that was the hot topic about AI. So again, we sort of have to look at ourselves as sort of the consumer protection hat. Then our perspective is that, well, my goodness, how do I protect consumer from, aggressive application of AI? And of course, we do, from a professional point of view, and you probably do have that concern also, but then it's as a tool, especially for the younger generation, I think that's more intuitive, and that's the direction that's going. But I think it is a hot topic because we are in the very early stages of experiencing it, and obviously the technology has not matured yet, and matured in terms of using it as a practice. One of the questions is that for diagnostics, are we going to be using AI to do assessments in substitution of a professional's judgment? What's that going to cause? How do we control? How do we, as regulators, and one of the things come to our mind is how do we protect the consumers from being hurt, right? How are the information going to be protected is another hot topic also from as AI gets into it. And we have all this, how do we cut through even currently HIPAA issues that we have. It's hard to between medical professionals, there are a lot of issues in terms of looking up a patient's information because of HIPAA, right? So how does that interplay of artificial intelligence going to be in that informational protection is another topic that they're talking about. So there are many different issues, but we all know, and then we all, and you guys are young, but I think the older generations do remember the Y2K issue, right? I mean, you know, we were like, everybody's preparing, you know, to jump off the cliff, thinking about the Y2K, and it was how it was represented in the market also, right? But we did spent a lot of resources and preparations, and that's probably part of the reason it went out smoothly. But the impact was not as what we have kind of sort of imagined. So it's just my sort of a personal feeling is that, you know, AI is a train that left the station. It's in a slow motion, and depends on how that, you know, do we want it to, you know, intentionally slow that down so we can put in guardrails to know where it's going to go, or do we just let it run, you know, its course? So that's something that I think it's going to be the next, you know, 10 years at least. That's and then it's up to you guys. I mean, you guys know this stuff a lot more than, you know, the older generation in terms of. I'm not saying that we're not, but we're slower in learning that, and you know, than you guys, and you guys see it, and that's part of the innovation is going to be coming from. Innovation in terms of, you know, how to approach treatment in the future.
And kind of thinking about the regulation of it and the Practice Act, I know, like it's been mentioned, the California Practice Act is looked to as a good example of where states, you know, should be or may want to be as far as how it's written. And it's stood this test of time, and there's been changes over the years, such as telehealth. And it's like, and so the board has to consider, do we need legislative change? Do we need rulemaking changes or regulation changes to consider these new innovations or new changes to the practice? And sometimes that is required, but sometimes it still fits within the language of the Practice Act, such as telehealth, because we get questions about telehealth and payment method, cash versus insurance, and how does that work? And you know, it all fits within the way the Practice Act is written, and the same supervision requirements, same documentation requirements. So just because there's changes or innovations, it may require a change, but it may not. So, and that's something that the board will consider as more information comes up.
Actually, I just thought about something because at the conference that was shown to us, I think part of the design for your test is going to be it's all on a video demonstration instead of, right, for, you know, the physical part of the instead of just, you know, like a written answer type of format. So I mean, that's part of I think technology is moving into and changes that perspective that provides, you know. So yeah.
Okay. Thank you very much.
Any other brave souls? Going from the back somewhere? I don't know.
So I'm going to ask kind of a broad question, and I may have follow-up depending on what you guys choose. I'm very interested in increasing access for physical therapy. What are some of the issues that you guys see at the forefront of that, and how are you participating in increasing that access?
I know recently, in the last few years, there has been what we refer to as direct access, in the sense that consumers can access a physical therapist without going to a physician to get a diagnosis. And there are parameters on that, 12 visits or 45-day limitation. And then after that, if further care is needed, they have to get the plan of care needs to be signed off by the physician. But that was carried by the association because that gets into an expansion of scope, not because in that case, you're not required to get a diagnosis. So there's kind of a guideline that this board looks at, where if it's consumer protection, it's something that the board will look at carrying and pursuing. If it's for a licensee, then the association obviously will carry that, or specifically in legislation. If it's beneficial to both, the association would look at pursuing that, because it really needs to, we really need to focus on the consumer protection aspect, which can include access, but also it gets into the area of expansion of scope, particularly in that issue. I think there's other issues like insurance coverage, but typically that's dealt with the insurance companies as well. I don't know if the professional members would like to kind of chime in this area too.
Yeah, thanks for starting that answer, because it kind of spurred me. I can think of a couple of examples. In the last few years, there was legislation where the profession drove the legislation and then came before us and asked for support, and it definitely was something that was an access issue that the board took support positions on. And one of them would be physical therapists who work in school settings. Mm-hmm. And being able to hold a certain credential so that they didn't have to wait to treat the patient until they got a clearance from someone else. They were able to be part of that decision. That's just one example. Another example, there was something in the last year regarding insurance and not having to wait for pre-authorization. And so some of us have seen this with our own eyes, where we want to go back, we want to see that patient, we want that patient to return to us, but our hands are tied. And so these types of legislation on access are really important.
I think that we don't bring bills, right? But what's amazing is that being on this board and identifying the limitations and being able to basically just focus ourselves in the position of your mom, your sister, whatever, your neighbor, and identify, would this actually help them get access to us, you know? That's kind of what we think about every time we look at something that comes across. So I think we're always processing it in terms of that perspective. Did I miss anything?
No, you remind me that we are also public members. We're licensees, but we're public members as well, right?
Getting my shoulder.
So we wear that hat too. Yeah.
So I had the opportunity of working at a workers' comp outpatient clinic this summer, and I got to see a lot of different people come in who were there as provided with workers' comp insurance specifically. And a question that I kept coming up in my mind is, once they were discharged from our care, a lot of these people maybe worked multiple jobs and didn't have the ability to access cash pay. For the particular individual who does not have the means through insurance or through their own cash pay, where do they go? What is their opportunities for access to physical therapy? And is that an issue that you guys talk about, that segment of the population?
I don't think we talk about it enough. And that's a very unfortunate position, and I think a lot of people are in that position. So, I mean, just off the top of my head, pro bono clinics, but those are hard to find, right? So we often get calls to the university asking if we have anything or any resources like that. I also know many times physical therapists have a heart of service. Do you have a service component to the program at all, or?
Yeah, we have several pro bono clinics, and I think it's, when I was choosing a doctor program to be a part of, that was the reason why I chose Sacramento State, is because they had those opportunities. And so I'm curious what other organizations. I'm glad to hear that that's one of the things you said.
I was just going to say, well, it was just another legislative item that did come up regarding postpartum care. And there was a bill in California, but there was also a federal bill giving access to Medi-Cal patients for opportunities for PT for postpartum recovery. And I know that was one thing that we sent a support letter for this board, because that would be a group that would not normally have coverage.
Mm-hmm.
And we're in support of that, knowing that that is also an at-risk group.
Mm-hmm.
So, I mean, yeah, I hear what you're saying, and I'm not sure of those avenues that we have. Except for, I can actually say that our president is very, very adamant about encouraging people to go into areas that are in need of physical therapists. And just as our other board members said, there are many opportunities to get tuition, forgiveness, et cetera, if you're working in Native American services, if you're working in the military, if you're working in certain populations that require that are at risk and are underserved.
Because the board doesn't get involved really with like insurance and billing and things like that, so we can't have, typically if a consumer calls and says like, I don't have insurance, where do I go, that we don't have a lot of resources to direct them to a specific facility or area or how to do that. However, this is becoming part of a conversation, because in the legislative report there's actually a bill that's on the governor's desk right now, and it has to do with the HCI, healthcare accessibility, something, I'm sorry, I can't remember the full acronym, but what they're looking at doing is they're looking at healthcare workforce, and what the bill is proposing is that it would be required for you to disclose your national provider identification number as part of a survey on your renewal, and that would be through us. And the Office of Statewide Planning would take that number and look at where you're providing care, because what they're focusing on is underserved areas. And how do we get care to these underserved areas, which would be tied to also the method of payment. So I would think that would be part of the discussion as well. So that's becoming more of a topic that's, that the board is looking at. And the board, the Department of Consumer Affairs, as well as the state, and how we can address that. So that's a good question.
And it is an advantage to have someone on the board who can relate to that. I can relate to that. And I can be the voice of the community that I'm a senior now, senior citizen, come in and be the voice of seniors, not only in my community, but in other communities. When these topics are brought up, otherwise you would never hear, you would never know that there is a healthcare desert in the Compton, Linwood, Carson communities in the SoCal area of the state. And so, once again, that's the role that a public member plays.
Thank you.
Thank you. Any other questions? We're getting close to our time. I told the students till 3 o'clock. We're getting close, but I actually have a question, if I'm allowed. I'm no longer a student. Student of life.
I'll allow it.
What's that? You'll allow. Thank you. Oh, yeah. So legal counsel approves. Sorry. What prompts a change to the Practice Act? I understand if there's changes to legislation if a bill is passed, but are there any other triggers that might prompt a change to the Practice Act? And how does that happen?
So the Practice Act is generally the statutory provisions in the Business and Professions Code that govern physical therapy. Those are all statutes. Those are all required to be adopted by the legislature as a bill. How a bill becomes law. I imagine if you remember the Saturday morning cartoons, the little bill running
Yeah, I just talked about this in class last week. So
yes. Also part of the Practice Act is the board's regulations. And so we've talked a little bit about that. The board writes those regulations, and then they're approved by the board, and then they go through the regulatory procedure to be approved by state government, which includes public comment responses to the comments. So if there are some things that can be done by regulation, but you have to have a statutory basis for that. So, for example, the board has pretty wide latitude to, let's say, continuing education. The board can make some changes about how they do that, but the board likely cannot, without a bill, state something to the effect of, as part of every physical therapist's biannual continuing education, they must complete a course on X. That's probably something that the legislature would have to do, because we wouldn't have authority to go that far.
Okay, so thanks. So do you find that sometimes there are regulations that, although they fall under the statutes, maybe aren't working as they should? So they were written at a period of time when those seemed relevant to the practice in California at the time, and then, maybe as a board you recognize that, this particular regulation needs to be changed. And so does that happen, and what usually prompts that? Is it instances of people coming before the board, or is it more is it agenda driven, and that the board is kind of looking to see how practice is changing? What is the environment like? And we actually need to modify this.
So most of those changes, because you're talking about policy changes in perhaps the scope of practice, and other policy changes that would have to come from the legislature. And if you think about it, this is the executive body that carries out the will of the people as expressed through the legislature in statutes. Legislature adopts the law, makes all the big decisions. The board implements the law, and at times what the regulations do is sort of fill in the gaps. So if it's any, I keep using this today, so dry needling, the board could not write a regulation to adopt dry needling. That would have to be done via bill and would have to be added to the scope of practice of physical therapy in the Business and Professions Code.
Got it. Okay. Thank you.
And then the trickle down from that would very much include how we process evaluation of ability to do it, like we do for our needle EMG, right? Our EMG regulations.
Yeah.
That might include something that's additional that we have to implement, and that would be another level.
Okay. And let me get back to your comment about, let's say, continuing competency, because you talked about it. So there's a statute that states that physical therapists must undergo continuing competency for relicensure, and it's fairly broad. And then, of course, the board makes a regulation related to the certain number of hours of ethics, basic life support, and then other methods of continuing competency. So are there times that the board might consider, well, this needs to change because it's not meeting the needs of the public? And so I guess that's kind of what I'm getting at. How would you change your agenda given the latitude you have with writing the regulation, not the legislation, with writing the regulation?
It's happening now.
Oh, okay.
Specifically to continuing
Okay, all right,
competency.
perfect.
Yeah, so it's a great example. And it's also a great example of how, since it's happening now, keep your ears open because you can contribute to this. Yeah. We can hear your voices on it, but very soon staff is going to bring forward to one of our board meetings some language on what they propose the regulation should look like. They'll bring what is existing, and then they'll maybe add some things, put some comments. Board members, what do you think? Public, what do you think? The association will probably chime in. And then we'll come up with some language, right? And we'll get some back and forth again with the public, and then we'll agree on something. We'll make a motion, we'll adopt it, and then staff goes back and they put it all together one more time and then bring it back to us. And now we have a new rule that we'd like to implement, and then it's got to go through the DCA process.
Okay, great. Well, what drives the sorry, go ahead.
No. To contrast,
yeah.
Right now there are some things that we can't do. Again, there's some things we can't do in regulation. So in this context, so there's a 30-hour continuing ed requirement
Yeah.
going forward. Let's say the board didn't think that enough. The board really thinks it should be 130 hours. That's a little joke. So say the board thinks it should be 40 hours. Okay, there's some new things in physical therapy. We think physical therapists need a little more time. That is something that is within the realm of the board's duties in implementing the program. That is something that it would be appropriate for the board to suggest to the legislature. And there's sort of every 4 years, 3 years, 5 years, depending on the board, there's a process by which the board goes before the legislature they're called sunset hearings because every board is destined in statute to blink out of existence at some point, and you have to go back to convince the legislature that it's still important to regulate physical therapy. So as part of that process, the board can suggest changes. That's something the board could suggest, but it would still have to go to the legislature, be adopted by the legislature, and then trickle down to the board implementing.
All right, thanks. And then I'll follow up one final, but kind of related to this. So what then drives that change? So if we're looking at a change in continued competency requirements, where does that start? I guess I'm trying to get into the minds of the board here, or really, what is the process? How does that come about? Is it feedback from the public? Is it just board members have an idea, or?
So I think in both cases, so like in legislation, it can be driven by, things will change the sunset report. So when we are reviewed, when the board's reviewed by the legislature, as Mr. Knotes had discussed, sometimes we can identify things that may be issues that we need to clarify this law or change this, and then we will propose that to the legislature, and they may take that up and make that change. Legislation can also be changed. The CPTA can make a proposal to change a bill. They would need an author, so they have to go find a representatives that would carry their legislation. It can also happen through an organization or any individual that finds an author to take up the cause that they have. So, it can be, you may have seen on our agenda, we did have animal rehab legislation that's been considered. And so that's something that's an organization, individual who wants to change an area of law to consider animal rehab, and that they found someone to carry that legislation. And that was, the bill is no longer active, but that's an example of something a proposal that was brought forward. So anything like that goes through the legislature. If there's legislative change, that can prompt a regulation change. So, for example, continuing competency, you have to have a program. That's what they told the board. Then from that, we go, okay, well, we need to know what that program looks like. So then the board developed the specific requirements for continuing competency. So those regulations were prompted by a change in legislation. Regulation changes can also be prompted by time, we see this as outdated, this requirement's no longer needed, or maybe it needs to be amended. A lot of those are typically identified by staff. So it's just experience and in working with licensees and the programs and seeing like, oh, this is outdated, this is no longer. For example, one we were discussing is the basic life support. There's hours in we have questions about that. Does the hour requirement still apply? So that could be something the board could consider in continuing competency to make that change in the future. So those are the types of things that then, if we think it could be updated, staff will propose that change before the board publicly. The board would consider it, and then there can be public comment, and then it would move through a process, a Department of Consumer Affairs legal process, Office of Administrative Law, and then after all of that could be become a new regulation. So as far as the origin, it can come from a lot of different places. I hope that was. Okay.
Scott, as a board member, my experience has been the last example where staff is doing the job every day. They're in the nitty-gritty, and they might notice something over time just doesn't fit anymore, and it needs to change. And so I think in my experience on the board, that's what I see, is that staff is like, let's look at this regulation again. And then they'll propose some language or some things to consider and then bring it to us, and we all hash it out.
All right, great. Can that come from the public as well? I mean,
So typically, it would be something like, and that's what I mean by like staff. So staff
Yeah.
working, and we get feedback from licensees and members of the public all the time. And it could be a phone call, it could be an email, it could be we look for trends in something that maybe not working in the program anymore. So it does a lot of time originate from stakeholders,
Okay.
and that's what may prompt staff to then look at that and make and recommend or propose those amendments.
Great, thank you.
Mhm.
Anything final from anyone? No? All right. I did tell them we'd be done by 3 with this, if that's okay, unless you want to take up more of their time. No. I really thank you so much. This has been wonderful. I hope you've enjoyed it as much as we have. It's been insightful. And credit to the students. So they haven't had the talk from Jason Kaiser yet. So we were hoping to actually have that before the board meeting, but it just didn't work out. So they came into this, I guess, a little blind to what the board does. So I think they've done a really good job coming up with some thoughtful questions, and then when they have the talk next week from Jason, I think it'll become even a little bit more enlightening and helpful for them. So thanks.
Can I share a little
Yeah.
secret? So it would be really awesome. Thank you for being here, and make sure you stay connected. Don't be strangers to the board. But if you join social media soon, so we have Facebook and Instagram and Twitter, or X, I'm sorry, and TikTok. Thank you. And then we have a mailing list. So if you all could join that, that might be a question that Mr. Kaiser asks you when he comes to visit you. And so if he says, so you can be like, already done, already on social media. So you might have that opportunity. But thank you all for being here.
And really quick, I'm not taking over, but our next agenda item is public comment for items not on the agenda. What that means is at any time, any of you can come to one of our board meetings and be heard on whatever you want to bring forward to the board. We won't be discussing it probably, but if you have an idea, you have a thought, this board really wants your input on items.
So we'll probably end up adjourning in like 5 minutes, but stick around and see if there's something that you might want to participate in, maybe even sooner than 5 minutes.
Scott, thank you so much. Students, future PT, thank you so much. And your questions were amazing, amazing. And please know that we don't take those questions lightly. So thank you so much for that. So I'm going to pick up the meeting, and we are going to move on to agenda item number 22, public comment on items not on the agenda. This is your moment.
I think they strained their brains hard enough just coming up with questions.
Okay, well, go ahead, Mike. No, I thought you were going to say something. Okay, yeah. Yeah. So next on our agenda, agenda 23, agenda items for future meetings. Board members, public, hearing none. This meeting is adjourned at, what time is it?
3:06.
3:06. Thank you, guys.